Good morning, everybody. Happy Wednesday. Welcome to the Courtroom Files Live. Let's start our day with Judge McNally.
The victim here that Kelly Campbell, is she out there, Lisa?
No, not on Zoom.
All right, so I set this case, or this was scheduled, I should say, for 8:30. It is now 8:49. We did not receive a victim's rights statement, and she is not here, so restitution, if any, will be handled through civil litigation. Your client pled guilty to operating while visibly impaired. That's on file A. The super drunk charge was dismissed, and he also pled to failure to report a property damage accident, and to leave the scene was dismissed. Have you had a chance to review the report with him, and are there any material additions, corrections, or deletions?
We have reviewed it, Your Honor. There are no material additions or deletions that I need to address. I'd just like to make some comments on his behalf if possible.
Sure.
Mr. Markin is 35. He has no prior criminal history at all. He's a hard worker, works at Ford Motor Company. He's been there for 12 years. He has a second job in security, but because of this, he lost his CPL. He may be restricted on what he can do or if he's able to work there at all. So he has received some consequences because of this. He's a married man with 2 children. I believe he's really remorseful with respect to this. He made a decision after this happened not to drink. He also started AA on his own voluntarily, just to get an idea as to learn more about alcohol and issues and how it affects people. You then made it a bond condition. He has continued to do so. But he has not drank at all, and his plan is to continue not to drink at this point. He's a competitive golfer. He golfs in a lot of tournaments and golfs pretty regularly. There's been a lot of alcohol at these events. He has passed on it every single time. He's been open with friends and his family about not drinking, and they've been very supportive of him. The only thing we're asking with respect to the sentencing is if the court would consider, instead of 12 months, perhaps maybe 6 months. And also, instead of outpatient, you'd consider an alcohol education program. To touch on the restitution, I don't believe there will be any. The vehicle hit a tree and then left. The tree, I believe, had a little bit of the bark was torn off, but it wasn't knocked over. So there's probably not any restitution. So I'd be surprised if there were. But Mr. Markin, I think, is taking this serious. And Your Honor, I've had a conversation with him multiple times, and he's got friends and family in law enforcement, and we've all talked about a first offense is obviously something nobody wants, but a second offense really affects your ability in your future. So I think he's heeded this. He does not feel he has a drinking problem. He's been able to control it. He feels really good about himself, and he's going to continue to do what he's doing, and he'll follow the conditions set by the court.
Sir, excuse me. Is there anything that, and you've seen his AA verification, Mr. Weinberg?
I have, Your Honor, and he has it here again. I can.
Okay, as long as you've seen it, he's been going once a week since May the 7th, so that's fair. Okay, good enough. Is there anything, Mr. Markin, that you would like to say, sir?
Yes, Your Honor. I've taken this very seriously. Like Mr. Weinberg said, I let family down. I have friends and family in law enforcement. I've taken this very seriously. I started doing the AA before, and I haven't drank. I don't plan on drinking. I'm glad that no one else was hurt. I didn't hurt myself, the safety of others. And that's it.
Okay, I'm sorry. Is that it? Are you done? I didn't want to cut.
He said that was it.
Okay, I'm sorry. All right, good enough. The only thing that troubles me here is you basically drove off the road and drove into a tree and you drove onto somebody's grass. If you did score in category 4,
so you got to take your hat off.
I'm going to place you on probation for a period of 13 months. You cannot leave, and this is on the operating while impaired. You cannot leave the state without the consent of the court or violate any law or ordinance. If you change your address, your place of employment, or home telephone number, you must notify probation. You do have to report as directed. No alcohol, no illegal drugs, no marijuana. You're not to purchase, possess, or consume any one of those things. Kratom poppy seeds and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. I'm going to order that you submit to chemical testing, PBTs and ETGs. They're recommending bi-weekly. I'll make it bi-weekly for 3 months. If you're clean, I'll make it monthly for 3. If you're clean, it will then be on demand of the probation department. You're to attend AANA once a week until you're in outpatient treatment. I'm going to order outpatient treatment, and I'm going to order the victim's impact panel. So you just have to go to AANA once a week until you're an outpatient. Once you get in an outpatient, you no longer have to go to AANA. No contact with the victim, Kelly Campbell. Restitution, if any, will be handled through civil litigation. I'm going to order 4 days jail credit, 1 serve 3, and I'm going to let you serve those as follows. 2 days on the court work program. There's a $35 a day charge for that. And 1 day of community service. So you can do the community service at any nonprofit organization of your choosing. You have to do 8 hours, and that has to be completed by September the 1st. Court work program days will be scheduled for you. As I said, there's a $35 a day charge for that. And that pretty much covers it except for fines and costs. $300 in fines, $250 costs, $75 victim's rights fee, $50 justice assessment. So fines and costs are going to be $675. You have probation fees of $260 for a total of $935. You have a $60 screening fee for $995. You have cost of recovery of $150, bringing your total here to $1,145 plus your court work program fees of $70 for $1,215. If you violate, your probation could be revoked. You could be incarcerated for 93 days. You have 21 days to appeal. You have 14 days to apply for a court-appointed lawyer for purposes of appeal. You also, you may be eligible for early discharge. So if you've got everything done in 6.5 months, you can come back and petition. We'll be glad to discharge you early. On the failure to report, I'm not going to place you on probation. I'm simply going to go 100 fines, 100 costs, 75 victims' rights, $50 justice assessment. Again, 4 days jail credit, 1 serve 3, and I'll have you serve those by way of court work and community service. So 2 days court work, 1 day community service. Those will run concurrent, so you don't have to do 6 days. You only have to do 2 court work and 1 day community service. Let me just make a note of that they're concurrent with that imposed on the A file. So you have 21 days to appeal, and you have 14 days to apply for a court-appointed lawyer for purposes of appeal if you cannot afford one. Do you understand that?
Yes, Your Honor.
All right, Mr. Weinberg, any questions or anything else?
No questions, Your Honor.
Can he pay this today, or does he need time?
He's gonna need some time, Your Honor.
How much do you have today, Mr. Markin? So you owe $12.15 plus 3 1/4. So you actually owe
$15.40.
$15.40.
He could pay $140. Could he start knocking it down, and then he would need some time for some payments from there?
You said 140?
Is that what you said?
Yes,
Yes,
sir.
Sean.
You pay 140 now on the failure to report. That's the B file. How about if I have you pay that one by then July? Can you pay that one by July? Well, how about August 1? Can you pay the rest of that, which would be another $185 by August 1?
Yes.
All right, and then on the other case, on the A case, I'm just gonna have you pay $125 bi-weekly, and we'll begin that on August 15th. Can you do that?
Yes, Your Honor.
Now, if you ever need more time, no problem, call the court. on or before the due date, we'll go on Zoom, or you can walk in here on or before the due date at 8:30. I'll be glad to give you an extension, okay? I don't care how many times we have to do it. Just don't ignore me, all right? Anything else, Mr. Weinberg?
No, Your Honor. Thank you.
Mr. Markin, any questions, sir?
No, Your Honor.
All right, best of luck. So
Have a good day.
I should have them call over to probation at extension 245-671-0201, extension 245. See if they want them to come in today or another day, okay?
Okay. Thank you, Your Honor.
Nice to see you, Mr. Weinberg. Take care. Good luck, sir. All right. Dylan Hall? Still in James Hall here? This is file number 5B148235 A and B.
That's Miss Patillo's case and they need an adjournment.
I see that. Is she here?
Yeah, she's our house counsel today.
Okay. Is Mr. Hall here? Do you know, Lisa?
No, he had some type of emergency.
All right, let's get her in here, Joan. Okay. You want to give me another date, a couple of weeks out or so, or?
July 30th at 8:30.
Okay, let me just make sure there's nothing that's going to prevent him from coming here then. So he's got a hold of her, she'll come in and go from there. July 3rd.
Well, good morning once again, everybody. Welcome to the Courtroom Files Live. Once again, happy Wednesday. Since he's shuffling around paper and it's not the most entertaining thing in the world, let's go to Judge Simpson and say good morning to him.
And or revoke. Do you understand the nature of that charge, sir?
Yes,
That's a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. Your vehicle could be subject to immobilization. You understand that, sir?
yes, I do.
All right. First question I have for you is, do you want to be represented by an attorney?
Yes,
All right. Public defender case. Sorry, didn't mean to wake you. No.
Good morning, Assistant Public Defender Lauren Perny on behalf of the defendant. We waive further reading, stand mute to the charges.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea to the charge. He's looking for an adjournment of the pretrial.
Please, Your Honor.
Pretrial in this matter will be adjourned to
August 6, 2025 at 9 a.m.
August 6, 2025, 9 a.m.
Mr. Perez, are you still gonna be in custody on August 6th?
yes, I am.
That's gonna be the next question. Better.
Okay.
And you're in Jackson County?
He's in Oakland.
Open, all right.
So that you know, I have his status as revoked for whatever reason.
Thank you.
I will, so that he gets credit on this, I'll set his bond at $5,000. I'll give a 10% privilege on that if he's going to be in custody. Standard conditions, including no assault behavior, possession of any weapons, no alcohol, recreational marijuana, or any illegal drugs. All right. Thank you. Thank you, Mr. Perez.
Thank you.
Court does call the cases of the people versus Timothy Haslam. Hold on.
Good morning, Your Honor. Christina Bergdarian requesting permission to practice pursuant to Michigan Code Rule 8.120 under the supervision of Assistant Prosecuting Attorney Ashley Lundy.
Permission to practice is granted.
Thank you, Your Honor. Christina Bergdarian for the people.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Haslam. Mr. Haslam, please state your name for the record.
Timothy Haslam.
Thank you. What are we doing?
So, Your Honor, one case is a sentencing.
Case do you have as a sentence? I have this one. No, I thought that was in warrant status. It might have been, nobody removed the sticker, but
Yeah, I think it was at some point.
all right, I got it.
We did review the pre-sentence report, have no material changes, additions, or deletions. We do ask that you adopt the recommendation.
Mr. Haslam, anything you want to say before I impose sentence?
No.
I will cancel the outstanding bench warrant in this matter, sentence you to $125 statutory fees, $99.99 restitution to Meyer payable through the court. I'll make that due 90 days after release. I'll order 93 days in jail, credit 93 served. All right. That's that one. On the other one.
You're not on the other one. We do have a resolution. However, we do not have a plea form filled out. So I did speak with Ms. Lundy. We were wondering if you wanted to adjourn it out.
What is the resolution? You guys gotta.
To plead guilty to no operator's license on this person. That was all.
Fill out the form. I'll take it so we don't have to bring him back.
I just didn't have his permission to sign it. That's why we didn't
That's count 2.
have it prepared. Correct.
Count 3, actually.
Yes.
And then 1 and 2 dismissed. Is that correct?
Yes, Your Honor.
Mr. Haslam, can you raise your right hand, please? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name again for the record, please, sir.
Timothy Haslam.
All right. Mr. Haslam, it is this court's understanding that you are going to be pleading guilty to an added count 3 of no valid operator's license on person. That is a misdemeanor punishable by up to 90 days, $100 fine plus court costs. Do you understand that, sir?
Yes.
And understanding that, do you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt.
Yes.
Okay. You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
Probation.
All right. Were you on probation on October 26th of 2024?
Yes.
All right. I do have to then advise you that this could be considered a violation of your probation. If it is considered a violation, that other court could sentence you to the maximum allowable under that other charge. You understand that, sir?
Yes.
You understand you're giving up, I'm sorry. You also, has anybody promised you anything other than what's been stated here today on the record? My apologies.
No.
Thank you.
Has anybody threatened you or coerced you in any way?
No.
You're doing this voluntarily
Yes.
of your own free will,
Yes.
and also because you believe that you're guilty of this offense?
Yes.
I will advise you that if you do commit misconduct as defined by the Michigan court rules between the time of my acceptance of this plea and sentencing, then any sentence evaluation the court would not be bound by. You could also not withdraw your plea. You understand that, sir?
Yes.
Counsel, are you aware of any promises, threats, or other inducements which have led to this plea that have not been stated on the record?
No, Your Honor.
No.
Sir, on October 26, 2024, at the location of Washington Avenue near Gulfside, were you operating a motor vehicle?
Yes.
Were you stopped by the police?
Yes.
Did they ask you for a driver's license?
Yes.
Were you unable to provide a valid driver's license?
Yes.
All right. Counsel, have I complied with the court ruling? Would it be proper to accept this defendant's?
Yes, Your Honor.
Satisfied, Your Honor.
Court will accept the defendant's plea to count 3. Counts 1 and 2 are dismissed. Sir, anything you or your counsel want to say before the court imposes sentence?
No.
Your Honor, I would just ask for a time served sentence. As the court knows, he's been in Macomb County for almost 2 months, I believe.
Well, okay. I'll give him all of the credit. I don't think that it really matters. I'll sentence him to $125 statutory fees, 90 days in jail, credit 90, sir.
Thank you.
All right, you're all set. Thank you, sir.
You're welcome.
Court does call the case, People versus Ryan Slay.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Slay, who appears via Zoom. Sir, can you please state your name for the record?
Ryan Slug.
Thank you.
Thank you, Your Honor. I have, this case was previously set for final settlement conference, and then, of course, Mr. Slay was taken into federal custody and he failed to appear for that final settlement conference. I was successful in talking to him again, and we are asking to reset this case for a final settlement conference. I will note for the court that he is currently at the Bureau of Prisons in Milan, but he's expecting to begin a transfer this coming Friday. We don't know for sure. Ultimately, he'll be ending up in Hazleton, West Virginia, but he may be staying in Oklahoma for some time. All that to say, I'm not requesting a date, but I believe a writ for Hazeltown, West Virginia for an October final settlement conference date would make sense, because we know for sure he should be there by then.
All right. I'll set jury final settlement conference for October. Say again. October 17th, 2025, 9 a.m. Jury selection if necessary. 20th.
Yes.
October 20th, 2025 at 8:30. Counsel, so that he doesn't have to be transported, because both of those proceedings are in person. If there is a resolution to this matter somehow, let's try to get that done so he doesn't have to be transported out.
Understood, Your Honor.
Bond will continue in this case. Thank you, Mr. Slay.
Thanks, Mr. Slay.
Thank you.
Court calls the case, People versus William Parker.
Good morning. Tom Piotrowski on behalf of Mr. Parker, who is standing in court to my right.
Sir, your name?
William Parker.
All right, thank you. What are we doing?
We are working our way towards sobriety court. It's just taking a little bit longer than what I anticipated, just asking for a couple more weeks.
Matter August 6, 2025, 9 a.m. Bond continued.
Thank you, sir. Thank you.
Court does call the cases of the People versus Tiara Peterson.
Public Defender Natalie Pate with Peterson, code is ending in 0150.
What's, pardon?
Miss Saxon on the other piece.
All right. Miss Saxon, could you put your appearance on, please? Is she frozen?
Yeah, she might be.
Oh, she's gone. Oh, no,
I turned her camera off that time.
you gotta,
Yeah.
Miss Saxon?
Good morning, Your Honor. Tina Saxon for Ms. Peterson on case 241. I was doing.
Got it. Okay, what are we doing?
Oh, sorry.
Good morning, Your Honor.
Good morning, Miss Saxon. Ms. Peterson, can you state your name?
Yes, Howard Peterson.
Thank you. All right.
Good
what are we
morning, Your
doing?
Honor. Tina Saxon on behalf of T.R. Peterson for case number 2410.
Okay, for the third time, what are we doing?
Your Honor, in my case, I'm requesting an adjournment for 2 reasons. I did reach out to people last week to see if we could possibly work something out as far as the resolution goes. I believe we still need to have a discussion. And then I do need to have a conversation with Ms. Peterson as well. So I'm asking for an adjournment in my case ending in 0150.
And Ms. Saxon, what are you intending on doing on your case?
Your Honor, I'm asking for a final settlement conference date, please.
Okay. All right. So in the case ending in 0150, I'll adjourn that matter to August 6, 2025, 9 a.m. Bond on that case will continue. On the other matter, jury final settlement conference will be set for August 8th, 2025 at 9 a.m. Jury selection, if necessary, August 11th, 2025 at 8:30. Both of those proceedings are in person. Bond continued. Thank you. Thank you. Court
Thank you,
does
Your
call the
Honor.
case People versus William Dapkowski.
Good morning, Your Honor. Paul Tefelsky on behalf of Mr. Dopkowski. Your Honor, it's date and
Your
time.
name, sir?
William Dubkowski.
All right, go ahead, sir.
Your Honor, date and time for pretrial. Last time we adjourned it for him to be evaluated by sobriety court, and my client got the evaluation, but then I think the probation officer and the evaluator were both on vacation, so it has been completed. The probation officer gave him a date of August 13th for his evaluation with him. And he said it would probably take a week to get his report done after that. So could we potentially come back August 26th or whatever date?
So you need a date after August 13th.
Plus a week.
Plus a week. Which sobriety court is this?
It's here in this district. I think for Judge Freshour's sobriety court.
All right. I'll adjourn the matter. I need a date after August 20th, please.
September 3rd, 2025.
Adjourn this matter September 3rd, 2025, 9 a.m.
Thank you, Judge.
Bond will continue. Thank you. Court does call the case People versus Ricky Ballard.
Hearing for the people.
Yes, good morning, Your Honor. Robin McCoy, P630057, on behalf of Mr. Ricky Ballard. Okay.
Your name, sir?
Ricky Ballard, John.
Thank you. I have before me a plea form that indicates the defendant will be pleading guilty to the charge of operating while visibly impaired, first offense and 93-day offense. On a successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement. Yes.
That's correct, Your Honor.
May I have him sworn?
Do you solemnly swear or affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Go ahead and put your hand down and state and spell your name.
Ballard Jr.
Has he executed, hang on, sir. Has he executed an advice of rights?
I thought he did. He said he had.
I don't have one. I need
Okay, we'll just.
to execute
I
one.
could have-
I'll pass the matter briefly.
Okay, that's
Sorry.
sorry. Sorry about that.
Court calls the case People versus Eric. Is it Casey?
Ready, Your Honor.
Christina Berger for the people.
Good morning, Rep. J. on behalf of Mr. Casey. Judge, I was just recently appointed. I don't have the discovery yet, and I've been told there are videos, so I'm asking for adjournment, Your Honor.
That objection, August 6, 2025, 9 a.m.
Thanks, Judge.
Bond continued. Thank you. Court calls case People versus Natasha Olmos.
And I'm
David-
gonna, actually, for the people, I'm gonna sub in on this one, Your Honor.
David I. Goldstein appearing on behalf of the defendant.
Jeez, oh Pete.
Well,
Because I think I might have made a mistake, and I don't want Christina to suffer for my
She
mistake.
needs to take it.
I thought it was because they needed a senior prosecutor to deal with the senior attorney, but
Ashley's not that old. She's just.
I'll remember that.
Wow, okay.
Your Honor.
Guess all deals are off. So, go ahead.
what deals?
Yeah.
Your Honor, I did make an offer to Mr. Goldstein to allow his client to plead to count 1, dismiss 2 and 3. I did not reduce that to writing. Does the court need a plea form for that if they're?
I do.
Okay,
I do need
apologize.
a
I'm
plea
so
form on that. And your name, ma'am?
Natasha.
Okay,
Morning.
almost.
Yes.
All right. All right. Let me pass it briefly. I'll get you right back up. I'll see once I have that form.
I apologize, Your Honor.
And she needs to execute an advice, right? Because I don't have one. Court does call the case of the people versus Rick Artuso.
Christina Bergderian for the people.
The Assistant Public Defender Natalie Pay on behalf of Rick Artuso, and the case is ending in 1656 and 1657.
Morning, Honor. May it please the honorable court, David Burgess on behalf of Rick Artuso as to the remaining matter.
Your name, sir?
Rick Artuso?
All right. What are we doing?
Your Honor, there's, people have indicated there were some potential other charges coming through, and they're trying to kind of, it's a restitution issue, and they're trying to kind of put this package up as far as a resolution. There's a pending matter in front of Judge Conlon at Circuit Court as well, Judge. So I was going to suggest an adjournment of the pretrial to try to attempt to resolve it. So.
Okay. So if I understand what you're saying, there's a case that's pending before Judge Conlon that may have restitution issues in that one also?
They're all larceny cases, Judge. So there's
Gotcha.
probably going to be a combination of restitution in each case.
And then there are more charges coming.
Maybe I was told they're not sure. They might pack. That's part of it. They may package it up in a deal, but it's all kind of pending right now, Judge. I apologize.
Got it. No, okay, I got you. So when will a decision be made as to whether or not those are going to be charged or just packaged up?
I'm going to defer to the people, the seasoned Miss Londy over here. So.
Wow. Wow. Holstein and Burgess are in trouble. Go ahead.
The 2 old white guys are attacking just Londy.
I'm not going there. All right.
Your Honor, we don't have a time frame at this time, but we will update as soon as we do.
Okay, so why don't I do this? And are you joining with that? Peter?
Yes, I am. My case just require Mr. Artuso to go to the Secretary of State, and he was just released from custody on the 8th. So I'm asking for an adjournment.
I'll adjourn all of these matters to August 6, 2025, 9 a.m. See where we are.
Thank you.
We are on it.
Thank you, Your Honor.
Thank you.
All right, let's switch things up a little bit. Since the audience demands between 9 and 11% more Judge Boyd, let's get some of that out of the way right now.
Here on DeAnthony Gortley. And I think it's for a bond reduction. All right. Are you ready to proceed on this?
Yes, Judge.
All right, the court is calling 2025 CR 0070068 State versus DeAnthony Germonte Gortley. Could I have parties announced?
Dr. Whitlock for the state of Texas.
Robert Ramirez for Mr. Gordley, Your Honor.
All right, and Mr. Gortley is here by Zoom. Defense, do you have any objection to your client being present by Zoom?
No, Your Honor.
State any objections?
No, Judge.
All right, Mr. Gortley, if you can unmute for me, please. All right, hello. Mr. Gortley, you're appearing by Zoom. You can be allowed to appear in person in court. Do you have any objections to appearing by Zoom?
No, ma'am.
All right, so I'm going to mute you now and again because sometimes there's noise that comes from your end because it's at the jail. So, all right. All right, so we're here on defense motion requesting a PR bond or either to reduce bond. Is there an agreement or no?
The state does not believe there's an agreement.
All right, and state you're opposed to the PR bond?
Yes, Judge.
All right, and why are you opposed to the PR bond?
The state would argue just the type of offense
Jane,
and that the state believes the original bond set, I believe it was 7,500,
500.
would be appropriate for this offense. And yeah, that's the state.
All right, so, and defense? What I can tell
Your
you
Honor.
is based upon what he's charged with and based upon the new based upon what the governor has stated and given to the court, I'm not allowed to give him a PR bond for harassment of a public servant. Those are not my rules. These are the rules that I must follow. I tell everyone, it doesn't matter how I feel about something. I'm just going to follow the law. So he's not entitled to a PR bond. The court is not going to grant him a PR bond. We can talk about the bond reduction though. And if you would like to present evidence.
Yes, Your Honor. I'd like to call my client to testify on this case.
All right, Mr. Gartley, if you can raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
D'Anthony Germonte Gordley.
All right, sir, you may proceed.
Mr. Gordley, have you tried to make bond on the 7,500?
Yes, sir, I have.
And why have you not been successful?
I don't have like the resources or the people out there to help me. So I've been in here by myself trying to do it.
Well, what about your mother and father?
They're both deceased.
Okay. And I was aware of that when I asked that question. I just wanted to make that for the court. Well, what do you do for a living?
I dance and basically just make videos, and I work when I can, but I can't right now.
Were you able to save up any money while you were working as a dancer and making videos?
I was, but I don't have any access to my funds because I don't have my wallet in here, nor do I have my phone.
Okay. I've spoken with your sister. Has your sister been able to make contact with these funds?
No.
Okay. And where does she live?
She actually lives with someone that I don't even know.
Okay. But she's not in San Antonio area?
She's just not stable.
Okay. So, okay. But you understand that you would have to make, we talked about the PR bond. The court just told us that this offense does not qualify as a PR bond. So if the court could reduce the bond to a certain amount, would you be able to possibly make that with possible assistance from outside?
I'm not 100% sure, but it's possible. It's possible.
Okay. All right. I have no further questions, Your Honor.
All right, any questions?
No questions from the state, Your Honor.
All right. Mr. Gortley, I just have a few questions. Any objections to the court asking a few questions?
No, Your Honor.
None from the state.
All right, Mr. Gortley, have you ever had any type of diagnosis for mental health issues?
When I was younger, I think it was ADHD, but I don't, nothing since I've been grown.
Have you ever been prescribed any type of medications for mental health?
Not that I know of, no, ma'am.
All right. Have you ever in the past used any type of controlled substances?
If weed is a controlled substance, yes.
Yeah, it counts as a controlled substance.
Well, yes, ma'am.
Anything other than that?
No, ma'am.
All right. And do you have any type of, I know your counsel said that, asked you whether or not you had funds, and you said you don't have any access to those funds. Is that correct?
Yes, ma'am, correct.
All right. So if you had access to funds, how much approximately would you have access to?
Honestly, I wouldn't be able to tell you that exact amount because it's like so I get paid from Facebook and Instagram and TikTok and stuff like that because I post videos.
Okay.
So I don't know. It varies every month. It varies. It could be 200. It could be 1,000. It could be something within that range. But I don't know for sure because I didn't get to post as many videos as I did since I've been in here. I've been in here, going on 5 months now. So I don't have, I wouldn't be able to tell you exactly what's there because it's not residual income.
Okay. And I have no further questions. Oh, I'm sorry. One more question. If you are able to make bond, where would you have a place to live?
Yes, I will.
Would you be living with anyone?
Yes, I would.
And who would you be living with?
Most likely my girlfriend.
And does she have any children?
No, ma'am.
All right, so there would be no minors in the home?
No, ma'am.
All right, thank you. All right, State, do you have any information on Mr. Gortley's criminal history?
Yes, Judge, give me one moment. The state sees minimal juvenile history, but in 2018 probation for an unlawful carry of weapon. And that would be the extent of the history, Your Honor.
All right, no violent history?
No violence.
All right. Then, Mr. Gorley, one final question. What amount of bond are you able to make?
Honest, I don't have any funds right now. Like I would have to reach out to my people and see what they will be able to come up with, but I wouldn't be able to even tell you a number. I don't even want to lie to you, Judge.
Oh, no. I'm just trying to figure things out. All right, so the court is going to grant the motion to reduce bond. State, I know that you're not in agreement to the reduction of the bond, but you now know that the court is going to reduce the bond.
Yes, Judge.
So is there any request from the state with regards to a reduction in the bond?
The state would rather hear defense's suggestion and be able to agree with it.
All right, thank you. Yes. All right, defense, what are you requesting for a bond amount?
$500, Your Honor.
The state was hoping he'd say 1,000, but the state would not make a very effortful fight against said suggestion.
All right, I'm going to set his bond at $1,500. There's to be no residing with minors. All right, and if for some reason he's unable to make the $1,500, counsel, you can always come back and you can come back immediately. But
Yes, Your Honor.
my hands are tied, and we can go off the record. My hands are tied in the sense that he hasn't really expressed to the court the amount of money he has access to. So we'll start out with $1,500 and see where we are.
Yes, Your Honor.
All right, thank you.
Thank you, Your Honor.
Thank you.
You're
Thank y'all
welcome.
so much.
Thank you.
Thank you all. That being all may be excused, Your Honor.
Yes.
Okay.
That was weird. You know, he suggests 500. The state doesn't strongly object to it, so she triples it and goes with 15. You know, I've said before, I think Boyd has her mind made up long before anybody says anything a lot of the time, but that's just me. Let's do that thing here we love to do. Get your votes in early and often for denied. Let's go to Louisiana.
Have a seat, Mr. Green. Can you hear us?
Yes, sir. Good morning.
All right. Committee on Parole is called to order. Today's date is July 16, 2025. The time is 8:43. And my name is Danny Barra, serving as your chairman. My colleagues on today's panel are Ms. Ledoux sitting on the left and Mr. Freeman sitting on the right. The panel today at headquarters in Baton Rouge, Louisiana. Staff, would you please introduce yourself? Our remote location is St. Tammany Parish Jail. And would the staff there please introduce themselves for the record?
Corporal Jonathan Lott.
Okay, thanks, Mr. Lott. Today we have Mr. Warren Green. Would you please introduce yourself with your full name and DOC number for the record?
Tremel Green, 352460.
All right. You have a sheet in front of you right there, the parole revocation questionnaire that you had signed for that original hearing?
Yes, sir.
Okay. And you recognize your signature on there?
Yes, sir.
And at that time, you were found ineligible for appointed counsel based on Supreme Court guidelines. So
Yes,
here
sir.
we are. You ready to proceed again?
Yes, sir.
Okay. So it looks like we previously had a hearing for you on June 24th, and we ordered you to a transitional work program, but you were not eligible because of prior sex offender conviction.
Yes, sir.
So we back here today to make a decision on what we're going to do with you in lieu of our past that couldn't be done. So I'm going to turn it over to Ms. Ledoux, who's the lead person on this case. You have nobody here. Okay, we have nobody here in support of this. We do have a parole officer, Mr. Steve Everly, here to testify. We can go ahead and take his information now.
Yeah. You want me to speak?
Yes, Mr. Everly.
All right, ladies and gentlemen of the board, we're here today because Warren Green cannot abide by the terms, conditions of his supervision that he signed on both the 10/26/23 and 11/6/23. He was driving a vehicle while intoxicated. He blew a .07. He was admitted to smoking medical marijuana, which is not allowed unless it's authorized by your body. He knows that. So there was medical marijuana in his system, or marijuana in his system, as well as alcohol. He blew a .07. They charged him with reckless operation because of the .07. That the last parole hearing, he was deemed to put him in a transitional work program because of his violent offender status and his sex offender status. I do believe he was denied for that program. If he had had an accident, I don't think we're talking right now. He went so many years. He's on for manslaughter. He did so many years without smoking marijuana, and now all of a sudden he wants to smoke marijuana. In our history, medical marijuana is expensive, so they get the medical marijuana prescription and then turn around and fill their bags with regular marijuana. That's happened numerous times on my caseload. He was drinking and driving. He could easily had an accident and hurt somebody, which is not what we expect people that have been granted parole. I don't know what more to say. He was denied the program. We're asking for revocation at this point, ladies and gentlemen.
He did plead guilty to reduced charges though, huh?
He pled guilty to reckless operation, alcohol in a vehicle, and no insurance in the vehicle.
Since our last hearing.
Yes, it was on
June 11th.
Let me pull it for you, sir.
It's June 11th.
Yeah, June 11th. Yes.
Thank you.
The only reason it was reduced is because he blew a .07 and not a .08.
Mr. Everly, how long has he been in jail? Does it show when we put him in?
April 25.
April 25, that sound correct?
April 29th is when he was arrested.
Yeah, I
He's
just
been
want
there
to see,
since.
I just want to see if it had been a long time. Okay.
So you're talking about 3 months.
Mr. Everly, thank you for providing that input to the board today.
You're welcome.
Mr. Green, you pled guilty to the charges. Were you drinking and driving?
Made an initial hearing. I take full responsibility. You know, I did have 2 doctors earlier that night.
And how long had you been on supervision?
Since my release, October of 23.
23, October 20. So I could probably make assumptions, but I won't. So I'll ask you. So have you been drinking pretty heavily since that time?
I mean, honestly, I'm not a drinker. No, ma'am, I haven't. You know, again, like I said, I don't pass the buck. I don't try to deny what took place. I do understand whether I was drunk or not. You know, I did drink, and even buzz driving is considered drunk driving. You know, I do understand the severity of the incident, what could have took place. You know, so I'm not going to try to downplay it. You know, like I said, I'm not a drinker. I'm not a druggie. I've been working again. Last year I worked 2 jobs. You know, it's not making any excuses. I got a newborn child. I just ventured off into a new business. You know, the first time I was out, I went to a movie. I mean, you know, at that movie, I mean, my first time maybe at a movie at the movie tavern, I didn't even know they served drinks. So I took a gamble and I drank 2 drinks. You know, and this is the result of it. You know, to say the least. I mean, I don't do anything. I work. I go home. You know, like I said, I got a newborn son. It's just 4 years old. You know, I mean, 4 months old, and all I've done just been trying to just maintain. You know, I'm 49 years old. I'm not about to, you know, say, oh, woe is me. I mean, but, you know, in light of everything that I have accomplished, I've been went above and beyond in spite of this one incident to appease to whatever.
Okay. Did you say you had a job while you were?
Yes, ma'am. I managed and worked at a barbershop.
Okay, but, okay. I don't have any more questions. I'll defer to my colleague.
Had you ever been told by your probation officer you cannot have medical marijuana?
I was told this October of last year by Mr. Belfonts. After that was my first time ever since I've been released having a urinalysis test. And he told me then that he just basically stated, I need to be careful because this is not recognized by the board. Now, again, I'm not saying that, I'm not trying to, you know, disregard. Yeah, he did warn me. That was my first and only, and they did say it was not recognized by the board. But when I initially received the card, which was earlier last year, around about April or May, I sent the text to, if I'm not mistaken, Mr. Beverly. And I was not told by Mr. Beverly. Now, I'm not saying Mr. Beverly didn't do his job. Mr. Beverly didn't do his job. Again, but when Mr. Belfonts became my parole officer, my first ever urinalysis test was October of last year. And so that's when he stated that it was not recognized by the board and I need to be careful. I have not been subjected to another drug screen then, but I do have the medicinal card. And I was, you know, at the time, earlier in the previous, you stated that I was possibly riding around with it in my car casually. Well, again, true, but not true. Where I work at, when I get off the interstate, the dispensary is on my way to my job. I placed the order that morning, I picked it up, I went to my job. When I got off now across the street at the interstate is where the movie theater is at. So when I got off that evening, fiance at the movie theater.
Yeah, and basically, but I just wanted to know whether you had ever been told that you're not to use it. And they do have a statement in here that Mr. Balfance told you that it's not approved unless the board says so.
Right, and
But to keep getting it after he told you that. So, okay, that's all the questions I have. I have.
Sir?
No question.
I do have one more thing.
Oh, yes, sir.
It wasn't an alcohol, it was a styrofoam daiquiri cup in his vehicle. So him saying he had 2 drinks while he was at theater, he had a daiquiri in his car, which he must have picked up. So, and I do not let anybody have medical marijuana unless it's prescribed by or approved by your board.
Yeah.
They're all told the exact same thing. So.
Okay.
Thank you, Mr. Everly. Mr. Green, there are rules for probation for a reason. You know, if we didn't have rules, we'd have chaos. Mr. Green, you talk a good talk. I hear you. I appreciate, and I know it's real. But we have rules for a reason. And my vote today is going to be to revoke.
All right. Freeman? Okay, yeah, I don't see any alternative. You were told, and back in that much time, I definitely wouldn't have got me a marijuana card. If I'd have known, I'd have to go back to jail for 8 years. So, my vote is to revoke. We got to follow the rules.
And I'll concur with my colleagues for the same reasons. Today, your parole has been revoked. And this will conclude our business with Mr. Green at St. Tammany.
Denied.
No surprise. Exactly what we thought it would be. Maybe we'll get lucky again later and somebody will get approved, but we'll see. Let's go to Judge Stevens. Say good morning to him.
23 CR 1043 is now called the State of Texas versus Logan James Burrell. That's you?
Yes, sir.
Present with Mr. West, your attorney and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment? And we proceed in summary.
Yes, sir, please.
In summary, this indictment alleges that on or about March 21st, 2023, in Jefferson County, Texas, you committed the state jail felony of burglary of a building. Do you understand what you were charged with here, sir?
Yes, sir.
I don't have the paperwork yet.
I did it. This is a state jail felony, which means you are facing no less than 180 days, up to 2 years in the state jail, and a fine up to $10,000 can be assessed. Do you understand?
Yes, sir. 5 years deferred with restitution.
The agreement that's been reached is that you would be pleading guilty, sentenced, placed on deferred or unadjudicated probation up to 5 years in length. Restitution is owed in the amount of
3,000. That's exact.
It says $5,675 to Hampshire Finette Independent School District. There's $20 to the principal Rayburn of Hampshire Finette, which I've got this all with probation. There we have it. $5 to Principal Ashman of Hampshire Finette, and a restitution of $100 for a $50 stopwatch and $50 cash to Coach Carter of Hampshire Finette Independent School District. They went through and destroyed some things and stole some things, cash and. Why?
Yeah.
Don't shake your head. Did the devil consume you or something? You were out of your mind?
That's what I gave them their money back. I got the money back from the kid.
Say that again?
I got their money back from that kid. That's what he went through their desk and took all their stuff.
There was another co-defendant to say for the kid, there was another co-defendant. That's what he means.
Exactly.
But I gave him.
Did you commit a crime or not?
Yes, sir.
Oh, okay. You're responsible. And so they say there's a loss. And when there's a loss, it doesn't matter who has it in their pocket. Both of you are equally responsible for paying it back.
Yes.
What happened to the other one?
The other defendant is, we looked up earlier, apparently he's had an active felony for the last 2 years. He got arrested in May and is on the announcement docket for August 5th.
In here?
Yeah.
Oh,
I
okay.
think it's in here. I didn't see which court it is. Either here or next door, but yeah, he's on the docket. So there's he's coming through the system. Will be soon. But my client, as soon as he found out I had an arrest warrant with him.
The odds are high on that one.
I saw that.
The betting line is going strong right now in Las Vegas, if you know what I mean, on how that's going to turn out. The total amount of loss in this was what? The total amount.
Well, we've got $5,675. New Hampshire Finette. We've got 20 to principal, 5 to principal, and 100 to coach. So
5,790. That's my math, right? 5790.
Yeah.
See a picture of the no, just yeah.
5790.
No, wait a minute, I'm at
Always
56.
his other client on today's docket, had it, so.
58.
So that he didn't have to come to court.
5,800 even.
And then he called.
5675 plus 25 will make 5700 plus 700 plus 800. Yeah,
Even fraud, and it's.
You said that so fast, I didn't catch it. What's your final answer?
It's 5675 plus 20 plus 5, which that's 25.
Yes, yeah, that's an easy one. That's 57.
5675, so that's 57 and then plus 100. 5800, yeah.
How much have you paid back? You don't know?
Nothing yet.
I'm judge.
I thought you said you paid it back.
No,
I got it. Whenever the police showed up, talked to him or whatever, he admitted the crime, gave him the information, he gave a bunch of items and some money back and some stuff that he had. He did give some stuff back. That's what he's saying. Yeah.
So what's our plan with the other defendant?
Same thing.
Well, how do they, how are we going to do the restitution?
Well, you always say, and it is the law, jointly and severally liable.
Yeah.
If his co-defendant pays back some, he gets credit for it.
Okay, you're both going to be responsible for $5,800. That doesn't mean you both pay $5,800 and then that's 11,600 that goes to school. They get 5,800 somehow. You're going to be responsible for it. He's responsible, and I'll just work this out through the probation. But what's fair is each of you who are equally culpable pay a half. But that's not, the law says if one person doesn't, you're still doesn't pay or is unable to pay, you're still stuck for the whole amount as well as he is. But those who don't pay in a different way. And it's not.
I'll explain to him. I know what you're talking about.
Yeah. So you're going to be ordered to pay 5,800, but we will work this out through probation. And do whatever it takes so that each of you pay an equal share. But under the law, you're both going to have $5,800. Your guys in the back being tested.
Yeah.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes.
How do you plead to this? Guilty or not guilty?
Not guilty. Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes, sir.
I'm going to show you here what Martha States Exhibit 1. What's more, Stacy Exhibit 1, did you sign that document voluntarily, understand it, discuss it with your attorney, or the contents all true and correct?
Yes, sir.
Stacy Exhibit 1, 10.
No objection.
Not objection, did you? This states you are mentally competent to enter your guilty plea. It's free and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God. Is that
Yes, sir.
Look at that bottom line. That's your signature? Just your two letters of your name, LB, that's your signature? That's what you normally use?
Yes, sir.
Let me see your driver's license.
I got a picture of it. I lost my old.
Well, tell them picture.
It's actually
How long have you lost your driver's license? You gotta get that done.
You
think?
Have to move my address.
Meanwhile, while you're doing that, State's Exhibit 1 is admitted and for all purposes. And find you are pleading guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt. But we're ready to move forward to that. But the court is going to instead.
Driver's license to you.
Paper too.
Instead, place you on deferred or unadjudicated probation for 5 years. There will be terms and conditions of probation, including restitution in the amount of $5,800, which you will be primarily responsible for $2,900. But if the co-defendant fails to be able to pay their share, each of you are separately and jointly liable for the amount, then you would end up having to be just as responsible as him. But what we normally do is hold them accountable for their share. And other terms and conditions of probation, which will be normal and customary. Are you working somewhere?
Yes.
Where?
I do. Rough choose. Got a 15-foot bat wing.
Well, okay, at the end of the day, do you make a handsome income?
It's not bad with me. I live free.
How much you gonna be able to pay like a month for this?
The money that's what I'll be able to pay it.
Oh,
Pay it off.
He said he's going to pay off first.
okay, we'll get the 2,900 and then we're gonna wait and see on the other difference. Okay, please see the probation officer. What are you gonna do, James?
I'm waiting on the.
Yeah. Well, we gotta get back to another trial because I gotta be in the commissioner's court in 45 minutes anyway.
And it's for 30 days regardless, so we don't have any questions.
Okie dokie, let's go back to Judge Boyd.
Scott Simpson for Mr. Smith.
And are you Mr. Smith?
Yes, ma'am.
Counsel, have you received all discovery in this case and did you review it with your client?
I have, and I did.
Court will find that the state is in compliance with discovery. Is there an application in this case?
Yes, Judge. For regular, not for deferred.
All right, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, we are not. We are proceeding with the lesser included attempted fraud use possession to make this a Class A misdemeanor.
Any objections?
No objections, Judge.
Did you review the admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand the state is proceeding on the lesser included offense of attempted fraudulent use or possession of identifying information less than 5 as a Class A misdemeanor? Range of punishment is up to a year in the Bexar County Jail and up to a $4,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
He has,
Do you believe he has a rational as well as a factual understanding of the charges against him?
very much so.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Smith, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promise you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand that?
Yes, ma'am.
According to the plea, punishment is to be assessed at 365 days in the Bexar County Jail. The state recommends community supervision. There's to be restitution to St. Peter and Paul of $1,940. There's to be no contact with St. Peter and Paul and the MRT. Did you understand that to be a plea?
Yes, ma'am.
Defense, is that the plea?
It is.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
None.
Outside the agreement, the state is recommending their community supervision be for a term of 2 years. There be 100 hours community service restitution and no contact with St. Peter's and Paul. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense, the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence.
State offers State's Exhibit 1 and all attachments at this time, Your Honor.
And we've reviewed those, Judge. We have no objections.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty and the court will find you guilty. So here's my question. Did Frost Bank receive their money back or no?
No, I don't think.
Or did Frost?
Adopt it, so the complainant would be good, but I do believe Frost may be out.
All right, so do we know if Frost is out of 1900?
I can call and confirm. What I do know is that based on the stints, there were multiple missing things, but the state did limit to defendants' participation. But the state can get a confirmation and if there will be a restitution hearing.
I believe in what I've worked on it, that restitution was not made yet to Frost. My client understands that and is prepared to, knows he has to pay that over the course of his probation. We've already calculated how much he has to pay each month to get it caught up. So I think it should be ordered, Judge.
All right, and so with regards to the $1,900, when do you expect you'll be able to pay that?
I can do it within 2 months if I need to.
To be realistic, though.
Realistically, within a year. Yes, 6 months to a year.
So how much money can you pay down?
Down?
Today, like today. You're talking today, right, Judge?
Yes.
Today, 0. Just in all honesty.
All right, so when will you be able to make a payment of $800?
Next Friday.
All right, so what I'm gonna do is I'm gonna reset this for next Friday. You're to come in with the payment of $800. Probation?
Following Monday, Judge.
The following Monday? All right. Oh, yes, no.
Thank you.
What date is that, Judge?
Let me pull you up. The 28th.
28th of July.
January 28th? I'm sorry, July 28th.
Yes, ma'am, absolutely.
Also, we're going to recall for July 28th,
For 800.
and you're to make a payment of $800. And who does he make that out to? Probation? State?
Actually, it's gonna be part of the state. If it's not.
Well, I'll communicate with the prosecutor between now and then, Judge, but it's gonna have to be in a cashier check or money order. So I'll get that info to you and I'll talk to Mr. Pitluck.
All right, and then your client was late today.
I understand, Judge.
Yes.
I would ask if you could recall the warrant and let him out so he can get this money
Yeah.
for next Monday.
State, do you have any objection to the court recalling the warrant so that he can obtain payment?
No objection from the state, Your Honor.
All right, we'll recall the warrant.
Thank you, Judge.
All right, thank you. Make sure you're on time. So your next court date is going to be July 28th. They're going to give you a reset form. Court is in the courtroom, okay?
Yes, ma'am, absolutely.
All right, thank you.
Let's go back up to Michigan, spend a little more time with Judge Simpson.
That's called the case of the people versus Christopher Banks.
Christina Berger, for the people.
Assistant Public Defender Natalie Pate with it on behalf of Mr. Banks. For the record, sir.
Christopher Banks. Thank you, sir. What are we doing?
Thank you, Your Honor. I'm respectfully requesting an adjournment. I just was able to get correct contact information for Mr. Banks today. However, he did show me that as the paperwork that the court required that he get for the veterinary records for his case, he does have them with him today. I will need some time to provide them to the court. He just has one copy. I do now have electronic copies that I can provide to the court. That being said, as to the pretrial, I'm respectfully requesting an adjournment to discuss the discovery with my client as well as with the people.
Any objection to that? All right. I'll adjourn the matter August 6, 2025, 9 a.m.
Thank you, Your Honor. And I do have copies of those vet records that I will send to the court and to the people, by the end of the day today. I
All
can
right.
safely say.
All right.
Thank you, Your Honor.
Thank you. Bond continues. Court does call the case People versus Luke Barrett.
Christina Berger, for the people.
This is a show cause for failing to appear.
Luke Barrett. No response. Bench warrant will issue for defendant's failure to appear. Bond 5,000, 10%. That warrant will issue immediately. Court calls the case People versus Thomas Bennett.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Bennett. Mr. Bennett, please state your name for the record.
Thomas Bennett.
Okay, thank you, sir. All right.
Your Honor, we are asking to set this for final settlement conference, please.
Jury final settlement conference will be set August 8th, 2025, 9 a.m. Jury selection, if necessary, August 11th, 2025, 8:30. Both of those proceedings are in person. Bond will continue with its conditions. Thank you.
You're all set, Mr. Bennett.
Thank you. Court calls the case People versus Damian Poupette.
Good morning, Your Honor. May it please the court. Ezra Goldman on behalf of Mr. Poupette.
Your name, sir?
Damian Poupette.
Okay. All right, what are we doing?
Your Honor, this is an adjourned pretrial. Mr. Poupette was going to get evaluated for sobriety court. And he completed the evaluation that he can do. Their results are not back yet. It's another one of those. So I have to ask the court for an adjournment.
Okay.
And I have to.
Which sobriety court is he?
This is going to be this one.
14A.
Yes.
All right. So he did the evaluation. Are we, that last case you heard, are we on that same timeline or?
No, we're a little better, except for my own schedule is a little, but the results are supposed to be back on Monday.
Okay.
2 days ago, but everybody's been, out of town and what have you, and they're all back.
Okay. So what?
So,
I have the September date, or I have, what's my Cause I'm gone.
Oh, I was gonna say August 20th, but the court's gone, the court's gone.
Well, I don't know if I'm gone that day. They just tell me don't come in. What day?
You can do September 3rd. Or.
I don't have anything earlier in August after the 12th. But would August 6th work, or I have to go to September 3rd?
Your Honor, last time I appeared by Zoom, the court complained that I don't like to come here, but I do like.
Well, that's true. You don't. I think I heard you before. My God, it was horrible.
So I just said another thing for September 6th. So one or the other, it's in Dearborn, so I'm gonna have to do one or the other by Zoom if we do the 6th.
Okay, why don't we do the 6th? Well, it's August 6th or it's September 3rd. So you said something for August 6th, you said?
Just now, like 10 minutes ago. So September 3rd, I have nothing so far.
Why don't I do that? I'll adjourn it out to September 3rd, 2025, 9 a.m. If it requires a plea be taken, if he's accepted and a plea be taken, counsel can contact my office. We can try to arrange to take a plea via Zoom so that we can get him moving, but we'll have this.
Appreciate that. Your Honor, I have to ask one more question. I know that people do not appreciate that, but I must ask. The tether is costing him $11 a day.
So Londi's not going to appreciate it?
No, she already told me she doesn't like my
Nobody's
question.
going to appreciate it?
No, I mean,
okay, no, I want to watch it happen.
I respect her objection to my question, but I got to ask it anyway. This tether is costing him $11 a day. Mr. Pupet works remotely, so he is home. He could test on a portable device as many times as the court wants him to, and be sure that he's not drinking.
What device is he on?
Ankle monitor, and I know that it's a second offense, and I know that it's a high BAC. I know all this, and I respect those objections, but I'm just asking. It's just purely financial. And
I understand, but I would leave that in place. I may, if there's an evaluation prior to that point in time, certainly you could submit something to the court in writing for my consideration, but
for now we're leaving it. I got you, Judge.
Okay. All right.
Have a very nice day.
Thank you. On continued. Court recalls the case of the people versus Ricky Ballard.
Robin McCoy, P63057, on behalf of Mr. Ricky Ballard.
I haven't sworn. I did. All right. Okay. I now have an advice rights form. As previously indicated, the defendant in this case is going to be pleading to the charge of operating while visibly impaired first offense. That being added count 2, count 1 would then be dismissed. All right.
That's correct.
You have been sworn, sir. Can you state your name again for the record, please?
Of course, Ricky Ballard, Your Honor.
All right. Sir, it is this court's understanding that you're going to plead guilty to the charge of operating while visibly impaired. That's a misdemeanor punishable by up to 93 days in jail, $300 fine plus court costs. The court could also order community service and any rehabilitative services the court deems necessary. The court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that, sir?
Of course, Your Honor.
All right. And understanding that, do you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, sir.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5 on that form. You'll see a copy of the podium rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily?
Yes, Your Honor.
Of your own free will?
Yes, sir.
And because you believe that you are indeed guilty?
Yes, Your Honor.
On May 10th, 2025, at the location of US 23 near Washtenaw Avenue in Pittsfield Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes, sir.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes, sir.
What'd you have and how much?
Tequila, Your Honor. Half of a pint, Your Honor.
All right. Were you stopped by the police or was there an accident?
Stopped by the police, Your Honor.
Why'd they stop you?
I was told multiple things, Your Honor. Speeding I was told that. I was told kind of running into the guardrail, or not the guardrail, the thing makes noise on the side of the road.
The rumble strips?
Yes, yes, Your Honor. And I got pulled over. Your Honor.
All right. Are you disputing the right of the police to pull you over in this matter?
No, Your Honor.
All right. After the police pulled you over, were you ultimately arrested?
Yes, sir.
Were you taken to the hospital?
Yes, sir.
Was there a blood draw?
Yes, sir.
And what were the results of the blood draw?
0.17, Your Honor.
0.179?
79, Your Honor.
Okay. Do you have any reason to dispute those results?
No, Your Honor.
All right. Sir, taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
Yes, sir.
All right. You also understand, sir, that while I'm taking your plea, if you commit misconduct between the date I accept your plea and the time of sentencing, that any evaluation by the court or any sentence agreement, the court would not be bound by. You understand that, sir?
I do, Your Honor.
And you also understand you would not be entitled to withdraw your plea.
I do.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have caused this plea to occur?
No, Your Honor.
All right. And have I complied with the court ruling? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Defendant is referred to Von Swartz for an alcohol screening and assessment and the victim's impact panel.
Okay, and Your Honor, my client did complete a substance abuse evaluation and there's a recommendation, which I can email it to the court and the prosecutor.
Well, don't send it to me. If there's an evaluation that's been done, you can provide that to probation, but I've referred him to Von Swartz. If that is acceptable to probation, I'm not going to have a problem, but if it is not, he must attend Von Swartz and do his assessment there.
Okay, just because he did complete it with Crystal Reyes and First Step Referral, they gave a recommendation. So, and they talked about the level for him. And let's see, they said
There's no reason to read that to me now. I'll be honest with you. You need to submit that to probation, as I've indicated. If that report is acceptable to probation, I'm not going to have a problem with that assessment being used for a sentence. If it is not, he must then go to Von Swartz.
That's fine. Okay, Your Honor, I just want to make sure that you know that he's taking this very seriously. He's never had anything like this happen before, so.
Sentencing in this matter will be
August 13th, 2025 at 9 a.m.
August 13th, 2025, 9 a.m.
Okay, would that be in person or
It is
via?
in person.
Okay, 9 a.m. 13th, okay.
Bond with its conditions will continue. Thank you, sir.
Thank you, sir.
All right, thank you, Your Honor.
Court does call the case of the people.
All right, let's go back to Judge Boyd.
Ms. Sanchez. And are you Ms. Sanchez?
Yes, sir. Yes, sir.
All right. Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney?
Yes, ma'am.
And also the First Amendment motion with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Are you the same Victoria Marie Sanchez who was placed on deferred adjudication in 2020 CR 2715 for the offense of possession of a controlled substance, penalty group 1 gram to 4 grams on August 5th, 2020 for a period of 2 years? Is that you?
Yes, ma'am.
And extended for a total of 5 years?
Yes, ma'am.
All right, state.
Yes, Your Honor. Violation of condition number 28. On or about the 11th day of April 2025 in Liberty County, Texas, the defendant Victoria Sanchez did then and there fail to comply with the rules, regulations, or instructions of the Bexar County Community Supervision and Corrections Department Substance Abuse Felony Punishment Facility Continuum of Care Treatment Plan, and that the defendant was unsuccessfully discharged for refusing to participate in treatment in violation of condition number 28.
All right, so what motion are you reading from? Because I don't see a violation of 28 on mine.
This one provided, it's under case number ending in 2715.
Is it a supplemental or something?
No, Judge, it was signed 5/13/2025.
May I show the court?
Yes, because I don't have that one. Okay, yes, I've been given the wrong paperwork. Okay,
Rely on the defense to give you the right paperwork.
okay. So to that allegation, how do you plead? True or not true?
True, Your Honor.
State, do you waive? Is that the only allegation?
Seeing that this is the only violation.
All right, yeah, I definitely didn't have the correct paperwork. All right. Did you understand by pleading true to violation of condition number 28, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition 28?
Yes, Your Honor.
Court will find violation of condition number 28 true. Is there a proposed agreement?
There's not, we are going open, Your Honor.
All right, state, what are you requesting?
The state is requesting that you grant the state's motion, revoke probationer and sentence probationer to 2 years TDC.
And defense, what are you recommending?
Judge, right now, this morning, Ms. Sanchez has 180 days credit. I'm asking the court to find her guilty of the lesser included offense of attempt to possess controlled substance 1 to 4, which is a state jail, and sentence her to 180 days in state jail, time served, judgment satisfied.
All right, why would I do that? She hasn't been successful.
Because you're a merciful and just judge.
Yes, but she has been, this is not our first motion to revoke.
It's not, Judge, and I think that Ms. Sanchez is having difficulty utilizing the resources available through SafeP. I don't think that there's any sort of remediation that is available to her that's going to help her move forward with her life. And Judge, I'm asking that you sentence her to 180 days, time served, judgment satisfied, so that she can get out, rebuild her life. Judge, she's a victim of sexual violence, and I'm hoping that when she does get out, that she can link up with Center for Healthcare Services and get some trauma therapy so that she can go forward with the rest of her life.
All right, and you have children?
Yes, Your Honor, I have 4.
All right, and see, that's the problem, because she was here when I placed her on deferred adjudication. I placed her on 2 years deferred adjudication, gave her all the tools that she could need, had her saying, work with CPS, had contacts for her for outpatient treatment, intensive outpatient treatment, did a referral to felony drug court. Then there was a violation and still continued her, did the weekly Zoom reporting to try to get her on track. And then there was another violation, and then she was sent to SafeP. So I'm not going to give you a judgment satisfied. I'm finding, and did you complete the CPS?
Yes, Your Honor, I'm actually getting my visitations. I was paying my child support for about 8 months. The last time you sent me for the 2 years, within those 2 years, I did 8 months, I think up to 9 months of job and paying my child support, and I was seeing my kids. So, I mean, right now I'm really having a hard time with my son, he just started middle school. So
Well, you know why you're having a hard time with your son? Because you're not in his life.
Exactly.
All you had to, well, you're saying exactly, but all you had to do was complete this probation. And I don't know if you would be a good influence on your son, because I don't know if you're still using drugs or not.
I understand that, Your Honor, but I feel like this has been the longest I've ever been locked up my whole life, and I think I've changed a lot, and I think I've learned the lessons that I need to learn to go out there and work and be there for my children.
You haven't learned any lessons, because we're here on another motion to revoke. And I always tell people, if you're not going to be clean and sober for yourself, which that's how you should always be, do it for your children. If there's somebody else you love more than yourself, do it for them. And you're not even doing it for your children.
I am, Your Honor.
And so that is why your son is having problems, because you're in and out of his life. Sometimes you are there. Sometimes you have motions to revoke. Sometimes you're using drugs. Sometimes you're not. That's instability for your child. And I'm not going to reduce this, and I'm not giving you a judgment satisfied. I'm finding 28 true, going to find you guilty, revoke. I'm going to sentence you to 3 years in the prison, give you credit for any time served. I'll request the therapeutic community. She'll receive any credit for successful inpatient treatment.
Very well, Judge.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Yes, I did. All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you're on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? Yes. We can go off the record. When you're released from prison, if you can't find a sober house, if you can't find someone that can help you, if I'm still here, you come back here, I'll pick up the phone, call somebody to try to get help for you, okay?
Alrighty, thank you.
All right, you're welcome. Good luck to you. Are they all here?
Yes, Judge.
Okay, so what you're seeing on your screen now has absolutely nothing to do with court, but I think it's really cool, so I'm showing you. This is Brooks Falls in Katmai National Park in Alaska. And the salmon are running, and you've got a bear just sitting there waiting for his dinner to show up, and nature's cool. It's the bottom line. I mean, it's cool and it's violent at the same time because he's just waiting to kill something. But it's amazing how it all works, and you know, the world is cool. Not everything is doom and gloom and bad things going on in court. Sometimes it's just good to quote unquote touch grass, as they say, or in this case, touch a waterfall. But just thought I'd share because it caught my attention as I was going through the feed, and thought you'd all appreciate it. So let's stare at that for a minute while I queue up the next thing here. All right, let's do this. Let's go back to Louisiana and do another one of those hearings, and I'll keep an eye on the bear for us.
It's July 16th, 2025, and we are at 9:11 a.m. My name is Danny Barra, serving as your chairman today. My colleagues on today's panel are Mr. Ledoux to my left, Mr. Freeman to my right, and headquarters, would you please introduce yourself? Our remote location this time is at Washita Parish Correctional. Is there any staff there with y'all?
Yes, sir.
Would you please introduce yourself for the record?
Good morning, it's Deputy Marchand.
Thank you. We also have Mr. Green. Mr. Green, would you please introduce yourself by giving us your full name and DOC number for the record?
Cortez Drew Green, DOC number 593070.
And I see you have a attorney there with you. Would you please introduce yourself?
Yes, my name is John Roa. Last name is ROA, and I'm his attorney for this limited purpose of this hearing.
Okay. All right. You have obviously, based on the questionnaire and the Supreme Court guidelines, you decided you are qualified for an attorney for this hearing, and we have him present here today. So we're going to go ahead and proceed with the hearing. I'm going to read the violations to you and ask you first just to go through all the violations, and we're going to get a plea, either guilty, not guilty, or guilty with a statement. Then we're going to take each one at a time and discuss them. So the first violation listed on the notice is that you failed to submit monthly reports to your parole officer as directed. How do you plead to that?
Not guilty.
All right, the second one is number 3, that you moved from your residence of record without permission from your parole officer before doing so.
Not guilty.
And number 4, that you engaged in criminal activity on April 19th when you committed the offense of domestic abuse, battery, and criminal trespassing. You entered a plea of guilty to criminal mischief and was by the court sentenced to time served, and the state removed the motion for psychological evaluation. How do you plead to that?
Guilty.
You failed to work at a job approved by your parole officer, and you have not provided any documentation or proof of employment since released on parole supervision.
Not guilty.
And number 10, that you have not paid your fees as ordered, and you're currently $819 in arrears on your parole fee.
Not guilty.
All right. We'll take them one by one. The violation number 2, you pled not guilty to, and in a notice of preliminary hearing, says you pled not guilty. You offered the following statement: I called the officer if I didn't go to the office, and the officer came to my house. Green explained he did not have transportation, but was in contact with his officer most of the time. Specialist Brown offered the following information. Brown started supervising the case in 2024. When Green wasn't reporting, he was seen by the officer at his home. Since Green said he had no transportation to the office, Brown advised Green left his home when he was arrested and should have been able to report on occasion. Green contacted officer to be seen at the residence instead of reporting for each month. This was done as a courtesy to Green. Green's conflict with officer was inconsistent. Contact with officer was inconsistent around January and February of 2025. Attorney Roa requested that have the reporting instructions clarified. Office contact and field residence contact briefly reviewed. Specialist Brown and Green was seen at home maybe 3 times since October, and it's possible the previous officer gave Green a chance to report by phone. What else do you have to say about that? What either one of y'all have to say about that one?
I don't have nothing to say, sir.
I have no knowledge of that, so I have no comment other than the statement that you already have from the officers.
Okay. So basically the statement I have is that you did not report monthly to them like they told you to. You would call them, but you didn't report to them. So on that one, guilty. The next one is that you moved from your residence without permission from the parole officer before doing so. What do you have to say about that one?
The address y'all saying that I moved to is an old address from my last probation, last time I was on parole and probation. The address always pop up. I don't know why it popped up. I have not moved from address. I'm still at the same address that's on file. The Ferran Street, I'm still there. That's my same address. Has always been my address.
All right. And that seems to be what you said at the preliminary hearing too. The probation officer, the following though. That the last address on record was Ferran, but Green gave arresting officer an address of 1401 Aaron, apartment 181. The affidavit stated Green was banned from the Fernan address. Officer was not advised of changes. Green then stated Aaron is the old address, that the uncle owns the property, and he was never told he was banned. That's still your statement for today?
Yes, sir. Yes, sir.
Number 4, you engaged in criminal activity on or about April 19, 2025, when you committed the offense of domestic abuse battery, criminal trespassing, and you entered a plea of guilty to the crime of criminal mischief regarding that case. So you pled guilty to that one, and you have been convicted in the court of law, so we'll find you guilty on that one. Condition number 6, you failed to work at a job approved by your parole officer. You have not provided any documentation or proof of approved employment since being released on parole supervision. What do you have to say about that one, number 6?
I have health issues. You know, I don't work. I have health issues. I have bad knees, and I got back problems. I have muscle spasms in my back from a car wreck. So I really can't work like this, sir. That's about all I got to say.
Do you get disability?
I've been trying, but it's been a battle with disability, sir. It's been a battle.
So basically, you did not have employment during that period of time that the parole officer specified.
No, sir. No, sir.
Had you brought him any documentation from the doctor or anybody like that to show him that you are disabled and unable to work?
It's been trouble getting around to get the paperwork. I don't have any paperwork on hand, sir. I don't have anything on hand.
Right. The next one we have is condition number 10, that you have failed to pay any supervision fees and you're behind $819 on that obligation. You pled not guilty. You did pay your fees or what's up with that?
Like I said, I'm unemployed, so the money that I have was real scarce, so I wasn't able to do that. But I received a check from a car wreck that I was in before I came to jail now, and I should be able to catch the fines up if released, sir. That's the only thing I can say about this, sir.
So what I understand is that you didn't pay it then, but you could pay it now.
If I'm released, sir, as soon as I'm released, I will get the check and pay y'all the back pay in full.
All right. We have your mother who would like to speak. Miss LaShondra Russell. Can we have Miss Russell can hear from her now?
Hello.
Hello.
My name is LaShondra Russell. I am Cortez Green's mother. Cortez was living at the correct address, the 2506 Ferrain, ever since the day I picked him up out of Winsboro when he was released. He's been there ever since then. Cortez did go try to find jobs, but I took him as much as I could because I'm trying to work 2 jobs to provide for Cortez. If Cortez didn't let me know that he needed help to pay his fees, because I would have helped him pay his fees. I just need for Cortez to be released so I can get him back on track with society. He's really off with society for being incarcerated. I've been doing the best I could with him. Trying to get him help with doctors and trying to get him help mentally, physically, to get him back out in society the correct way. And I did meet with his parole officer a couple of times, and she was trying to fill me in on what was going on, Miss Brown. I was trying to get her input on, okay, what that he's not doing that I can help him to do to get things straight and squared away.
All right. Mr. Pete has a question for you.
Okay.
Is he on any medication?
Yes, he is. Cortez was on, I think, a depression and a blood pressure pill. It's like 3 or 4 pills that he's on.
I was talking about for mental health. So he is on mental health medication?
Yes, I had Cortez committed down south. I can't remember exactly what it was. They gave him some medication to take. Yes, sir.
Okay, and does he take his medication?
Yes, he does. Since he's there, he hasn't took it. No, but when he was at my residence, he was taking the I was putting it in his hand every day to make sure he took the medication.
But he just went off that day, went a little crazy, huh?
I think we were out of medication and it was another refill at Walmart. I didn't get to Walmart at the time to get the refill.
You were the one that called the police though?
Yes, ma'am. I was the one because I've never seen him. I've seen him angry or whatever, but I've never seen him like that type of angry.
And in that altercation, that's pretty much one of the main violations here where he ended up pleading guilty to a lesser charge. What did he do to you?
Well, it wasn't really, the way the cops described it, it wasn't really that bad. I got off from work at 1. I went there. He had a toothache or whatever. He needed some toothache medicine. I was trying to get him the toothache medicine. We were downstairs in the townhouse and he stepped on my foot and the officers asked me what happened. I told him, well, he stepped on my foot and he called me a few bad names. And then later on, once he calmed down, he apologized. He really didn't assault or harm me or anything. He just stepped on my foot, which I think was an accident.
And why did you call the police?
Because he was so angry. I've never seen him that type of angry. I couldn't get him to calm down. And then I was trying, before the incident had occurred, I was trying to get another corner to get him some more help at another behavior clinic. Because he was going to primary health care is where I was sending him to see doctors.
Just to be clear on this point, you no longer fear any retaliation from him. You are 100% recommending that we would release him on parole back to your house.
He's more than welcome. That's my child. Never turn my back on my child. He's more than welcome to come back to my house, and I'm more to help him pay these fees.
All right. Yeah, but the question is, are you scared of him?
No, I'm not scared of my child. No, I'm not scared of my child. He sleeps in the same household as me. I go to sleep normal. He go to sleep. I'm not scared of my child.
Okay.
All right. If I could add something to this, I want to outline what happened with the charges. He was when the police arrested him, they charged him with criminal trespassing and domestic abuse battery. The DA declined the charge of domestic abuse battery and only charged criminal trespassing. Then they amended that down to criminal mischief on the day he took the plea. So the DA had looked at it and decided there was no domestic abuse battery.
Thank you. While you're speaking, is there anything else you want to say about this case as his attorney before we vote?
Well, all I know is what's in the record, because I just came on for this hearing and to try to help him out. I do know that there's a problem when you're in jail, because I have a lot of clients down here that, they have medical the prescriptions for mental conditions, but it's hard to get it when they're in jail. But from what I know, he has not had any problems out here, even though he's not taking the medication. And so I think if he could get out and his fees get paid and he gets back on his meds, he can work out some of this other stuff that's going on in his life.
Yeah.
Is the deputy still in the room?
Yes.
Yes, sir. Okay, I was reading the narratives. In the narratives, they had when the officer came to serve him, he refused to go back into his cell. Have y'all had any problems with him?
No, sir. No problems with him since he's been here this day.
Okay, thank you.
All right. Lastly, we'll give you, Mr. Cortez Green, a chance to make your arguments before we vote. This is your last statement.
I just hope that y'all can find a decision to let me out. I'm a changed man. I don't cause no problem. I just want to be free in society and do the right thing, sir. I hope y'all can see that I'm a changed person. That's all I have to say, sir.
All right. It would be time to vote. I'm going to ask for an executive session.
I second.
Freeman,
Yes.
Ross,
Yeah.
Badoo.
Yeah.
Okay, guys, well, they're in executive session. Let's do this. Let's go back to Alaska. It looks like our bear friend is getting his breakfast, so let's hang there for a second. Yeah, he's been moving around a little bit, Ashley. He actually, I wasn't able to capture it completely, but he caught that up at the top of the falls and then came down with it to eat. Probably because the water's a little calmer and it's easier for him to do that, would be my guess, but yeah. Is this camera live? It is live. It's a live feed from the national park, though we're a few minutes behind because I paused it so you guys could be able to see that he got his breakfast. So, all right, looks like they're back from session. So let's go back to the hearing.
Motion that we go back into regular session.
All right, the time is 9:32 a.m. and we're reconvening the parole hearing on Cortez Green. Mr. Green, we've come to a decision. I'm the lead member on your case, so I'm going to be the first guy to vote. And I'm going to vote to continue you on probation and not revoke you today on the condition that prior to your release, you go to Hunt Correctional Center and have a full mental health evaluation and get a plan and follow it once you get out. You got to get a mental health evaluation at Hunt before you release. And then once you release, you got to follow it and follow all the instructions of your parole officer. Reporting, paying, everything y'all said you could do, and be honest with them about where you're going to be living. It's on you to fulfill those responsibilities. The parole officer doesn't report to you. You report to the parole officer. You understand all that?
Yes, sir. Yes, sir.
Okay, that's one vote. Ms. Ledoux?
Mr. Green, you pled guilty to criminal mischief. This is a violation of your parole. My vote is to revoke.
Mr. Freeman?
Okay, my vote is to do not revoke, send you to our mental health evaluation, follow all recommended treatment. Okay, and I'm gonna add a curfew on you from 9 to 6. All right, good luck to you. Now go over there and get yourself straight.
All right, thank y'all. Enjoy y'all day. Thank you.
Thank you. You had a vote of 2-1, and it does not have to be unanimous. So today your parole is reinstated with conditions. This would conclude our business today at Washita Park.
Approved?
Weird, huh? Not often we see that out of Louisiana, but good for him, and hopefully he's able to get things together. Let's go up to Michigan Judge McNally.
So you go out in the hallway, and you'll come back in front of me after you speak to an attorney, okay? All right.
Have a seat on the way.
Harper, Aaron James Harper. 25B148510. Come on up to the podium, Mr. Harper. And then I'm gonna take Farrell, Mr. Bogart. Your name?
Aaron Harper.
All right. You're charged with defrauding an innkeeper. You have the right to a lawyer. Do you want one?
Yeah.
All right, we'll set you up with a lawyer as well. You can go out in the hallway and we'll take care of that momentarily, okay?
All right.
So, John, these are all there. Farrell? Jackson Farrell, 23B82267, 23B76671, 24B82280. Your appearance?
Thank you, Your Honor. Your Honor, Christopher Bogart on behalf of Mr. Jackson Farrell, who appears to be Zoom.
Mr. Farrell, your name?
He's still connecting.
So I think last time I told you guys, if it didn't resolve, I was going to set it for either jury or bench.
That is correct, Your Honor. After speaking with the prosecution, I also had an opportunity to speak with the ordinance officer here today as well. We are asking to set this for a final pre-conference. We don't anticipate on having a trial on this matter. It will be resolved on that final pre-trial if the court grants that. I'm asking for an opportunity myself to be able to go out to the property to verify the information that's being provided to me.
Remember, the blight charge is already in default.
I understand there's tickets that are in default here, Your Honor. There's also a misdemeanor. We're also handling the same charges in the courtroom next door as well with the prosecution. So we are asking the same thing in that courtroom. The only thing I can indicate, Your Honor.
Mr. Farrell, your name? Your name?
Jackson Farrell.
Good morning. I don't have a problem. I'll adjourn 2 more weeks, but that's it.
Thank you, Your Honor.
And if it's not resolved then I'm gonna have to set it for jury or bench. It's your preference.
Thank you, Your Honor.
Okay, what do you have for me, Lisa? July 30 at
9:30.
9:30, okay? No more adjournments though, sir.
Thank you, Your Honor.
Okay, do you understand that?
Can I get some more time to finish cleaning up?
Got until July 30. Okay? That's 2 weeks. That's
I
it.
will-
It's
I
not
will
done.
try. I will
Try.
try, but I'm limited in my ability due to
Known
my
about this since
blindness.
2024. I don't know what to tell you. I
Sir,
don't
I
need
was
to.
never notified.
I'm not
I
gonna,
have not lived in that.
Farrell, you
house.
don't need to explain, any of this to the judge, okay?
if it's not done by July 30, we're setting it for trial, period.
Thank you.
Okay? Thank you very much. Dylan James Hall, 25B148235, A and B.
Good morning, Judge. Deanne Petito on behalf of Mr. Dylan Hall.
Where is he?
So his father, and Judge, I apologize, his father reached out last week. They have some work issue, and so they did ask him for an adjournment well before today.
Work issue? I got a work issue. I'm working right now. Where's he at? What do you mean a work issue?
Work, I'm not sure. Can I get the prosecutor? Because he sent us both an email.
I'll call him.
Okay.
Work issue. What do they want us to do? Open court on Saturdays? I mean, come on. I was told it was an emergency, and that's one thing, but not a work issue. What, they gotta build the,
I know,
What is this?
I read something in the email about work. I'm not sure.
all right, let me see. No problem. It's not your fault. I'm not blaming you. Sometimes I find that people put these court matters on the low end of the totem pole when they should be at the top. Your name?
Caitlin Foley-Carter for Boston Township.
Why does he need an adjournment?
He works with his father.
Yeah.
His father and him, I guess, both, there's been an emergency at work and they weren't able to get here today.
He sent it a week ago, right?
He called me on Friday.
Well, this is Wednesday. That's 5 days before. What kind of an emergency?
I guess everybody else had to take off today, so there's only one person that could run the company and it was him.
What's his father had to do with it? Why couldn't he send the kid?
The kid didn't want to come by himself.
What?
I know.
How old is he?
I think he's 18 or 19.
Yeah, he's young.
He was able to go out and get a drug charge and a concealed weapon charge on his own. All right, I mean, I'll do it this one time reluctantly. We're gonna adjourn it to July 30 at 8:30. July 30. Tell him he has to be here, whether his father can be here, can't be here, mother can be here, can't be here. That's it. That's ridiculous. Have a good day. Thank you very much.
Thank you, Judge.
Kevin Michael Terry. I need you guys in here in about 5 minutes on this Boyd case, okay?
Okay,
Thank you. Kevin Michael Terry, 25B148684. Your name?
Good to see you.
How you doing?
I'm good, how are you?
It's good to see me.
Yeah, I've been in here before, but it's a long time ago.
Okay.
And we used to work at the same company a long time ago.
What company was that?
Fair Alloy, North American Steel.
I worked at North American Steel back in 1978. You were working there then?
I was working in 94 to 98. Then they shut the doors down. Closed down.
North American Steel, I worked at when I was in college. You know how much I made? And I was on the banding line, $4.45. That was during Christmas. My father said, before week off, he said, you're getting a job. I said, where? I got your job at North American Steel. I said, really? Well, you weren't working there in 78. You're way
No,
too.
I was working there in 94.
Well, I didn't work with you then.
No, we didn't work together, but I mentioned it before. The last time I was here was back then. And I mentioned that when I worked at, and you said that you worked there before.
I did, 1978 or 9, it might have been at Christmas. $4.45 an hour.
I was 6 years old.
And I worked as Yeah, that was hard work too.
Yeah,
Wasn't easy. All right, I'm gonna give you a lawyer. You want a lawyer?
sure.
I'll give you a lawyer. You're all set. Robert Thomas, and then you have to come back in front of me. Robert Thomas Boyd, 25BA2557. Yeah, he had a job all worked out for me and everything.
Good.
He was sure I was gonna. Anyway, Mr. Boyd, your name?
Robert Boyd.
Ladies,
Rob Harris on behalf of Brownstown Township Ordinance.
all right, you have the right to a lawyer. Today is the date scheduled.
No, thank you.
Okay, I gotta tell you this, though. You do have the right to a lawyer. Be glad to give you one at public expense. Do you understand that?
Yes, sir.
Would you like a lawyer?
No, sir.
All right, so just for the record, I went out and looked today. Mr. Boyd. Sir, I don't mean to be in the least bit disrespectful, but you cannot own a property in a township, in a city, around other neighbors, where it's just, I don't know how to say this without sounding rude. I mean, you got holes in the garage, you got inoperable vehicles, inoperable trailers and boats and weeds and that, and I wouldn't want to walk in the house. What are we gonna do here to get this resolved? Have you done anything since? Because I gotta tell you, the pictures, they had pictures. When were these pictures taken? You guys gave me pictures before. At one point, they're in the file.
3-4 months ago.
Well, it looked better 3-4 months ago than it looks now. Seriously.
It's only because of the growth.
Huh?
Only because of the growth of the trees.
Well, I know.
It's covering stuff.
I know. Sir, do you have any children that can help you?
No, sir.
Do you have any children at all?
Yes, sir.
How old are they?
52, 40, 48.
Boys or girls?
46. 2 boys and a girl.
Why won't they come help you?
Because they're working 16 hours a day, 7 days a week. Well, not 16, 12 for the oldest one.
Listen,
The youngest boy is.
I want to know what you're going to do to clean that property up, because
I'm gonna work on it every day like
listen,
that.
it looks like a, sir. Oh, I don't know what to tell you.
I'm only one guy, but I've been working on it every day.
What are you doing? What have you done? Tell me what you've done. It looks like you got vegetation all over, holes in the garage. It looks like the garage is gonna fall down.
Well,
Your house looks like it's gonna fall down. No neighbor should have to pull out of their driveway or drive down that street, or anybody else, and look at that property. Now, I don't mean to be mean. I mean, I get it. How old are you, sir? You're
77.
How long does this property look like that?
Since I know there's been violations there for, 4 or 5 years.
Boy, you're not doing what you're supposed to do.
But I'm doing it.
No. You gotta pick it up. What are you gonna do with that garage?
I'm gonna tear it down.
When?
I got a plan. I told you I had a plan.
Well, the plan, you've been in here, what's the plan? Tell me what the plan is.
Okay, the plan is, I got another trailer that's bigger. The trailer that's in the driveway belongs to my son.
Get him
I
out.
borrowed it to get some stuff out of the garage so I could start tearing it down. That stuff's gotta go into my trailer so I can move, and I've got underlayment to lay down in the driveway, to re-gravel the driveway. And, the trailers are going, I gotta put the truck into the shop today.
You told me when I was out there, you said rain date of the last 10 days. It isn't rain date of the last 10 days.
Oh, yes.
No, it hasn't. At night, maybe. Some of the time. It's been
Well, that's all
hotter.
it takes to wet the grass. Once the grass is wet, the lawnmower clogs all up. You can't cut the grass in the rain.
You haven't cut that grass in months. When's the last time you cut that grass? Come on now.
Today is Wednesday. I cut it Monday.
Well, it does.
I cut the
2 days ago?
Pardon?
2 days ago?
That's right. It
What
rained.
do you guys want me to order over here? Tell me what you want me to order, and then I want you to go slow.
Your Honor, we have a list. First, the inoperable vehicle needs to be removed.
There are multiple inoperable vehicles, are there not?
I believe.
They haven't moved. I don't know if they're operable. I mean, they do have plates on them. The one still has the flat tire.
I should have looked and seen when the tags were renewed. I did not do that. That was my fault.
They got good.
Wait a minute, wait, one moment.
Okay.
I did check all the tags. All the tags are up to date, but the vehicles parked in the grass, vehicles, not operable, not moving. The one car with the flat tire hasn't moved in, I'll just be nice and say over a year. The trailers in the back, the storage containers.
Hang on.
Everything's a fire risk. I mean,
I know.
but that wood is just.
All right, let's set a schedule. I want you guys to help me out here. All inoperable motor vehicles. First of all, do you want to say anything before I sentence you?
Motor vehicles have tags on them, they have insurance on them. I can only drive one at a time, but I'm driving junker, so that's why I got two cars. The Yukon I use for pulling my boat, pulling my wood trailer, I burn wood.
Hang on a second. So you're saying they're not inoperable motor vehicles, that they're plated, they're licensed, they got insurance, and you drive them. That's what you're trying to tell me?
Yeah.
How many cars do you have?
2. Three vehicles total. I put them there so I can stop the people from taking things.
Taking things?
Yeah, my tools that were in my tool trailer and garage. I'm out $23,000.
Did you make police reports?
Pardon?
Did you make police reports?
No, sir.
Somebody stole $23,000 worth of tools and you didn't?
23, yeah.
And it didn't dawn on you to make a police report?
No, because they had their finger in the pie.
Who had their finger?
4 times I caught them back there.
Who?
Charlestown Township Police.
No way.
Oh, yeah. I'll tell you what.
Wait a minute, slow down. You're telling me the police have been on your property and they're stealing your property?
Yeah.
Now be careful, because that's quite an accusation.
Yes, sir.
Any police officer stealing property.
That's why, what was the sense of me making a police report to the guys who were taking the stuff? The last time I caught them, it's always around 4 o'clock in the morning. I got up to go to the bathroom. I heard voices out there, so I put my bathrobe on and went around that RV trailer that you walked around. They were in the tool trailer. The one policeman was standing outside with one of the big flashlights, made a big LED flashlight, made a big circle out of it in the door so the guy in the trailer could see what he's doing.
I'm gonna encourage you, hang on.
Pardon?
Hang on. I want you to go over to the Brownstown Police Department when we are done. And I want you to file a complaint. If that happened, you go file a complaint.
It's gone.
You go file a complaint. If somebody's stealing from you, I don't care who it is.
I have made complaints before, and they've been out there and looked, and I've showed them things. Didn't slow anybody down, and they're not the only ones. The kids down the block were the ones that started it. They're the ones that poked holes in the roof. They're the ones that tore the windows out.
Are you making reports with the police? I mean, you told me that. I looked on the garage. There's no way kids are poking. Those are not hole pokes. Those are,
Yeah.
that is from total dilapidation of that garage.
They knocked the shingles off.
Shingles?
I mean, this has been a while going on. They've been stealing from me for about 5 years.
Mr. Boyd. I don't know what to do with this.
All right. I can tell you one thing.
Let's just stay on track here. You're throwing me for a loop. You're telling me the police are stealing from you.
That's right.
You should make reports. Police, I don't care who it is, has no right to steal from you. if you think I'm stealing from you, or the police are stealing from you, or kids are stealing from you, or anybody else in the world stealing from you. You make a police report.
Well, I used to, but nobody did anything with it. They still came back regular, took what they wanted anytime they wanted.
I'm floored. Do you know what
The
you're?
police, I'm not talking about the police. They were only there, that I know of, 4 times.
Who was only there 4 times?
The police. I've caught them back there 4 times.
Stealing?
Yeah,
Did you see something in their hands?
no. I didn't stick around that long.
Was this at 4 o'clock in the morning?
Yeah,
So you caught them there 4 o'clock in the morning and you went back in your house?
yes, sir.
Did you wake up and see the next morning whether or not something was missing? Yes or no?
I wouldn't know if it was missing or not.
Because you got so much junk back there.
Well, I got tools and materials.
You got
I did
junk
have-
back
I did have, they're gone now. I mean, they stole them all. Not the police only, there's one guy that lives back on Bully Drive. He was in there a lot.
Mr. Boyd. I don't know what to say.
I didn't want to, if you start a fight with the police, you lose.
That's not true.
It's my experience in life.
Have you ever come into court and had an argument with them and had judges rule against you and say they were right? That's not a fair statement. No, we don't treat people better because of who they are, what they do, who they know, or how much money they make. We don't do that here. And that's in this jurisdiction.
Well, that's in your court, sir. Yes, sir. I believe that.
Well, it's not my court, but let's focus here. I can't very well call them inoperable vehicles, but it creates a blight condition. You can't have even operable vehicles sitting in the property. It completely creates a blight condition. There's nothing but junk in there, sir. I mean, when's the last time you used that trailer or that boat?
Last year.
You used the boat last year?
Yeah.
You used the trailer too?
Yeah, the wood trailer I use every year, all through the summer.
The recreational vehicle, Judge, is full of, I mean, it's pictures I took today, I mean, they're, it's, I don't know what's in there. I mean, it's wood, it looks like the garage, the storage inside of the RV. I mean, you can tell just through looking through the windows, it's all the way up to the ceiling.
In what?
In the recreational vehicle, in the camper.
I've got a couple of tree stands in there.
I don't mean to sound rude. You're kind of a hoarder. You know that, right?
Pardon? It's what?
You're hoarding.
What I have is,
You're hoarding.
I
Now, I
have,
want you to tell me, nice and slow, what you would like me to order.
Your Honor, do you want me to put together an order for the court? Would that be easier?
I would love it, and we can come back another day.
I think that's wise.
Sir, I mean no disrespect. You seem like a very nice man. You really do.
Hey.
But you gotta get rid of that junk. You gotta get the garage torn down.
yes, sir, it takes a
You
while.
gotta get the vehicles out of there. You gotta get the grass cut. You gotta get the brush cut. It takes a while. When is the first time you guys had contact with Mr. Boyd about this property?
It's been years. I mean, there's been multiple ordinance officers out there. I inherited it from Dennis, who had it prior to, and then, it just.
So how long have you known that the township disapproves? Well, actually, let me rephrase. How long have you been maintaining a blight condition? And how long has the township known about that? How many years?
Well, I got cancer a couple of years ago.
Just tell me how many years. 5?
No.
6? 4?
What he's calling blight conditions is just the vegetation that's growing.
The vehicles. The vehicles are sitting in a field. The trailer.
They're sitting on my grass.
I know.
To block the driveway
To block the driveway from what?
from them stealing my trailer.
They're not gonna steal your trailer, sir.
Maybe, well,
How long has the time? You're saying it takes time.
it does. But I've been,
You've had 3 or 4 years. Let's not quarrel about it. You've had 3
it
or,
hasn't been like that all the time. I keep cleaning it off.
what do you mean? That looks like nobody's touched that in 10 years.
You know,
That's a nuisance. It's,
where the garden was, yeah. And I plan on putting that back this year so I can have a garden next year. And there was nothing I could do for a while because I had cancer and it took all my strength. I had it twice.
sir, I'm sorry, and I hope that you've experienced a full recovery, but you gotta do something over there. I'm adjourning this to July 30. You put together a recommended order. You send it to me ahead of time with do you take emails or just letters? Do you know how to use a computer?
Yes, but I just take letters usually.
Send me a letter, carbon copy him.
Yeah.
July 30 at 8:30, Lisa?
Yes.
I have a feeling you're not gonna listen to me, Mr. Boyd, when we come back.
I'm trying.
I don't think you are, sir. I don't think you are.
I'll have all the,
Why don't you get one of your kids to help you?
I can't, they live too far away.
Where do they live?
Well, the one lives, he works, up past 15 Mile Road. And, he's a manager of
All right, I don't need to hear all this.
yeah.
I just,
And the other one works for General Motors. And he works over on East Road. They work him 7 days a week,
good for him.
12 hours.
Maybe he can help you get some other workers over there with all the money he's making if he's working 7 days a week, and get some people over there to help you move the stuff, because I cannot let that go on. I don't want to come up, you seem like a very nice man, but I don't think,
I'm gonna move the 2 vehicles.
what about the trailer?
The trailer, I've got wood in it. I got my wood splitter right there. I don't know if you saw that.
Get the wood out of there. Get the wood out of the trailer and stack it somewhere nice.
That's
Get the garage knocked down. Can you do all that in 2 weeks?
no.
Well, let's move. I'm telling you, I'm not gonna be very patient on this.
I mean, I've got a plan, like I said.
Well, you know, I had a great plan to become president. I didn't make it. You gotta execute your plan. You better start now. You follow?
Yes, sir.
A plan? You've known about this for years. Send me your proposed, this is what you're asking. I don't want it in order form. This is what the township, you can do it in a memorandum form, file it with the court, send them a copy, and we'll see everybody here. But please stop telling me you got a plan. You need to get moving, sir. You need to get moving. That is a disaster over there. I'd be so upset if I was one of your neighbors. And now you're coming in with these outlandish theories that the police are stealing, the kids are stealing, they're poking holes in the garage. Let's just, well, then go file a complaint right now. If you think anybody is stolen from you, go file a complaint. If you think anybody's damaged your property, go file a complaint. You can't just let that go.
I never caught the ones that started stealing.
Actually, even on your own words here, for whatever reason, you're saying they were out there at 4, you didn't see them take anything, and you didn't check the next day, I think you said, to see if anything was taken. Who knows? I don't know. All I'm telling you is I'll see you in 2 weeks. Get the vehicles out of there, start cutting the brush, get the wood out of the trailer, and then I don't have to be hard. I don't want to be hard here. I just want the property cleaned up, okay? Will you do that for me, please?
Yes, sir.
All right. Thank you. Nicholas Edward Gilliland.
So one of the highlights of this whole thing for me just came a moment ago when my 82-year-old mother used the word dude in the chat. So That's I've never heard you use the word dude, Mom, so thanks for that. There's something more going on with this guy. There's a mental health issue. There has to be. He is exhibiting some of the signs that we started to see from a distance because he was on the other side of the country, but we started to see with my wife's father before he had his strokes. So there's something more going on there. Somebody make a note, if you would, July 30th, 8:30. That's when he's coming back. If I make a note, I'll lose it. But some of the regulars here, if you can make a note, and perhaps we can catch up with it then. Barbara, thank you for the gifted membership, the $5 super chat, and the additional shirt you ordered yesterday. Your continued support is appreciated. Julia, welcome to the TCF community, because I don't think we've seen you here before. At least I don't think you've been active in the chat. The TCF bunker is here in Arizona, just like you. I don't know if you saw it, but I dropped a link for a friend of the channel, Michael Groff, into the chat. Go subscribe to him. He does local weather, and he does it wonderfully. Watch him once, and you'll understand what I mean. And if you like what you see here, consider becoming a channel member, because we've got a great community, and channel members get extras, including access to the pre-show, which is something different every single day. Checking up on our bear friend. He's off in the distance if you look in the top right. Still looking for more breakfast. Apparently one big salmon was not enough for him. He needs more, and I don't blame him. Salmon's yummy, and he's big on sushi, it would seem, so good for him. Let's go back to Louisiana, and we'll try that again, because we're currently at a tie. One approved, one denied.
Denied. Approved?
That was a bonus stinger from our friend Michael Groff. I don't know how that happened. I forgot to disable it, but we'll see what really happens with this hearing.
We're going to allow public comments, 3 in support and 3 in opposition. We'll also allow the district attorney to speak if they're present, and then we'll conduct the parole interview. So today we have for parole consideration, Lionel Jackson, DOC number 582797, who's a second felony offender, who was convicted of cruelty to a juvenile, another cruelty to a juvenile, and habitual offender status. And on February 20th, 2020, was sentenced to serve 15 years hard labor and 10 years hard labor to run concurrent in Orleans Parish. Your parole eligibility date is 2/2020. Your good time date is not applicable due to the charge. And your full-time date is November 26, 2030. How does that information sound to you?
Thanks, sir.
Good. All right. Well, first question is, what did you do to get yourself in this trouble?
I was angry at the time. I didn't tell nobody, the police. I didn't tell nobody. I was strung out on X-pills real bad. And my baby mother, she brought my son over, and he was crying, and I was agitated, and I got real angry, and I grabbed him, and it wasn't intent to hurt him, but I grabbed him, and when I shook him, and when I shook him, he stopped crying. I laid him down, and when I laid him down, I noticed he was throwing up and stuff like that. So, I picked him up again. I walked around the house with him. He seemed fine, so I laid him back down. The next day, my baby mama came. She came and got him, and she took him to Children's Hospital because she said he kept throwing up, and they say something about shake baby syndrome and something else, some other injuries.
Why do you think now is a good time to release you?
10 years ago, I was messed up 10 years ago. I had a real bad anger problem, temper problem. I didn't want nobody to tell me nothing. You know, now I feel like I'm in a better place. I took anger management classes. That class helped me out a lot. Express myself more than to act out in anger. I feel like I'm a 100% better person than I was 10 years ago.
Anything else?
No, sir.
Okay. Jail staff, can y'all give us an update on how he's been with y'all?
Yeah, he has been fine, sir, here with us. No significant write-ups. I think he only has one write-up since he's been here. He is one of our trustees, works, we keep him pretty busy. And I have nothing else to say other than he does his time well here.
Looking at the support and opposition today, we have no one that wants to speak in support here, but we do have some people to speak in opposition. We're gonna start with Ms. Devetta Taylor, the mother of the victim in this case. Would you please go to the podium and tell us what you have to say regarding?
The letter should be on Zoom.
Okay. We'll still start with Ms. Devetta, but she's on.
Yes, I'm here.
All right, this is your chance, opportunity to talk to the parole board and tell us what you have to say about this case.
Good morning, first of all. I'm against it because still to this day, he still haven't acknowledged nothing when it comes to my son. My son was also hurt besides Miss Aranisha's son. And to this day, he still have not even acknowledged that he hurt my son. I have been through so much with my son after all of this, and I just don't understand how. Good. Okay, I understand he's doing good. He's off of his drugs or whatever the case may have been. Of course, you may have had anger issues. That's fine, but at the end of the day, you're acknowledging hurting one child. 2 kids was hurt, and not one time have I got any kind of explanation. Not one time that I have to go to the hospital because of my son with his epilepsy or anything else concerning his injuries due to what he's done to my child. I have to deal with that for the rest of my son's life. And still I have nothing. No apology, no acknowledgement, no nothing. So no, I don't feel like he learned his lesson. Yes, he acknowledged doing something to one child, but it's 2 kids that's involved. And I don't feel like he's changed. You still can't acknowledge what you've done. So no, I'm not, no, I will not support him getting out. No, I don't.
Thank you. All right, we have Miss Ornisha Riddler. Hopefully I got that right. Also a victim in this case. Who's gonna speak?
Against it. Because my son shook at me from 6 weeks old. He never gave me a chance. Because of what he did to my son, he had a cerebral palsy and epilepsy. My son cannot go a day without catching anesthesia. I have a normal life of a 10-year-old. He loves to do things that normal kids could do, but he cannot because of his epilepsy. This school year had to remove him from school because of his epilepsy. That is a seizure disorder. I cannot do anything without catching a seizure. I didn't drop him off to him when the incident happened. I know Jackson asked to get my son that week because he was old. And this is the first time I ever heard of what this son said. It's like, I would like him to continue the rest of his incarcerated and be punished for what he did to our kids. Lesson is not learned, like she said, she took anger management, and I never knew Lionel Jackson was on pills. I never seen the pill. I never even seen a pill from my house. I never seen them take pills. So the no day all this was going on, I never would have even dealt with a man like this. Never know even lay down as a child with a man like this. I'm totally against it. A guy has to get Botox in his legs because he has several pulls on the right side of his body, affects his right side of his body. He gets Botox. He's on 5 different medications. We think about doing a brain surgery because his seizures is not regulated. He don't have a normal life because his seizures, he can't go a minute without catching his seizures. He has 4 seizures in the daytime. Because the way he did to my child was born a whole month early. Had nothing, no problems. From 6 weeks, that's what happened to my son. He didn't even give him a chance. And a guy who a chance at a normal life. It is no thing to see.
Thank you. We also have Jazidi Dauphine, who no. Not speaking. All right. All right, we do have opposition from the Attorney General's office and the Chief of Police. The Orleans Sheriff's Office has a no comment policy. The Orleans District Attorney has no comment policy. And the judge in this case did not show any opposition. Your case has been assigned to Ms. Ledoux. So we're gonna let her begin the questioning and she'll be casting the first vote.
Mr. Jackson, how many children do you have?
2.
2? Okay. I think your master prison record must be wrong. Let's see, 5. Okay. How many counts of shaken baby or cruelty to juveniles have you had?
I think it's 12, 1, 2, 3 altogether, I think.
3?
Yes, ma'am.
Okay, I have 3 children, 3 mothers, and 3 incidences of abuse.
Yes, sir, ma'am.
Each of those families represent an entire victim group. Have you had victim awareness? You have anger management, your GED, but have you had victim awareness?
I'm in victim impact right now.
You're in what?
I'm currently enrolled in victim impact.
Yeah, oh, great. Great. Mr. Jackson, have you learned anything yet from victim impact?
Yes, I learned that for my actions, a lot of people got hurt. It's not that I'm not sorry. I apologize to everything I did to all them children. I'm not proud of it. No, I'm sadly distraught with it. Like I just was in a bad place and I didn't tell nobody because I was ashamed to tell anybody what my addiction was. So I just kept it away from everybody. I didn't bring them to the house. You know, when I went to work, I kept the pills at work. I kept the pills at my friend's house. That's why I used to go over. I just was in a bad place at the time. But I feel like victim impact showing me what I've done. You know, I watched stories of how people got hurt and what it done to them. No.
Let me ask you this. For you, you're a second-class offender. How did you finish your first term of incarceration? Were you this?
I did 17 months in Jefferson Parish, fighting the charge, and I ended up getting 3 years probation or something like that in Jefferson Parish.
So that was your first cruelty to juvenile,
Yes, ma'am.
and then you have these two. Okay. I don't have any other questions.
Mr. Freeman? I have no questions. I have no questions. We're ready to vote? Mr. Duke, you cast the first vote.
Mr. Jackson, based on your habitual, I believe that's an appropriate designation for what you've done. Nature of the crime, victim opposition, and you have not had completed your full victim awareness impact. My vote is to deny to you.
Mr. Freeman? Due to the media situation, I mean, the crime is just awful. And the victim's opposition, my vote is also to deny. And I vote to deny parole due to the age of the victims and the prior conviction for second-degree cruelty to juveniles. Also, the strong opposition from victim family and law enforcement. So, Mr. Jackson, today, the parole has been denied, and this concludes our business with Mr. Jackson.
Denied.
So I'm not saying, I'm just saying. He's right where he needs to be. And one of the benefits you get if you have access to the pre-show is you get to hear Dan's thoughts a lot more than you get here on the full live show. And tell me that this doesn't dovetail into what I talked about last Thursday, I believe it was, about doing the next right thing. This guy has no concept of what the next right thing might be. And he demonstrated that apparently several times. And how pathetic, how sad. But like I said, I think he's right where he needs to be. Let's go back to Judge McNally.
Court today is standing on my line.
Your name, sir?
Mark, Ron?
All right, so for purposes of arraignment, does he stand mute and waive formal reading?
Yes, Your Honor.
And then there's going to be a no contest plea to leave the scene, the property damage action with the failure to yield to be dismissed, right?
Correct, Your Honor.
You know that's 6 points, right?
Yes, Your Honor.
Okay. If you plead no contest, sir, it has this, and the reason for the no contest plea is possibility of civil litigation, true?
That's always a potential, Your Honor. We've reviewed the report. We don't dispute it, but it's also a scenario where he was under some medication, and so
lack of memory
of certain facts, Your Honor. But we believe the government has established the sufficient facts, and that's why we would like to take advantage of this opportunity.
No, I know, but I still need a reason for a no contest plea. It's either a possibility of civil litigation or lack of memory or lack of recollection. So whatever.
Civil would be the primary reason, Your Honor.
Was there another car involved, right?
Correct.
All right, so I'll just say possibility of civil litigation, which makes complete sense to me. Sir, if you plead no contest to this charge, the possible penalties are up to 100 fines, 90 days jail, costs are all those in 6 points. This does have the same effect as a guilty plea. Do you understand that?
Yes, I do.
And did you sign the advice of rights and read and understand the rights?
Yes, I do.
If you plead no contest, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yes, sir.
All right. Do you have any questions on any of your rights?
No, sir.
And the plea is going to be to leaving the scene or failure to stop or identify after a PD accident, property damage accident with the failure to yield to be dismissed. Correct, counsel?
Yes, Your Honor.
So to that charge, leaving the scene of a property damage accident, how do you plead?
No contest.
All right. Counsel, you stipulate I can use the report to establish a factual basis?
Yes, Your Honor.
I've had it marked Peoples 1. Based on my review of the report, I find there's a factual basis for the plea. Wow, you were drinking too, huh? I don't want you to say anything. I don't know what to say here. Are you on probation or parole, sir?
No.
Anybody force you to plead no contest?
No.
All right, they didn't run any field sobrieties or anything else, and didn't have a breathalyzer or blood draw administered. I'm gonna accept the plea of no contest. We're gonna notify the victim. I'm gonna order a screening and assessment. I'm gonna dismiss the failure to yield. We're gonna give you a new court date, Lisa.
July 30th at 8:30.
Good with you?
Judge, I'll be traveling out of state on that day. Is there an alternative that's
Good,
available?
yeah, good for you.
August 13th at 8:30.
August 13th at 8:30, is that good?
That works for us, Your Honor.
Okay, so August 13th at 8:30 will be the court date. You're going to go down the hall, sir. You're going to get your notice, and then you're going over to probation where you're going to be interviewed. And I'll send you at that time. Do you have any questions?
No, sir.
I am giving you a $1,000 personal bond. You're not to purchase, possess, or consume alcohol, no alcohol or controlled substances, illegal or marijuana. Do you understand that?
Yes, sir.
All right, good luck. We'll see you back here. Thank you. Thanks, counsel. Nice to have you.
Pleasure to be here, Your Honor. And just to clarify, is there an option for Zoom at sentencing? Or is it here?
As long as the two of you are in the same office. All right, you work for Honigman downtown, right?
We can make that work. It's just with some medical appointments, we're just making sure, and he's not driving right now, so this is potential. But we're here today. If the court wants us here in person, we'll be here, but
If you can both be in the same location, I'll be happy to let you Zoom.
appreciate that.
Either that or here, whatever you want, okay?
Thank you, Judge.
Nice to see you. Thank
Have
you.
a good day.
Good luck, sir. Do we have anything else ready down there?
No.
Okay, we're gonna take a recess until we get some. Stay seated, everybody.
He looks like he needs a recess. Let's see what we've got queued up here. Honestly, given the time left, the best place for us to go is back to Louisiana one more time.
2025. Time is 10:10 a.m. My name is Danny Barra, serving as your chairman today. My colleagues on today's panel are Ms. Ledoux to the left and Mr. Freeman to my right. We're still at Baton Rouge and we're still at the Allen Correctional Center as our remote location. We're doing a hearing on Mr. Tyrone Jackson. Mr. Jackson, would you please introduce yourself by stating your full name and your DOC number for the record?
Tyrone Jackson, 159715.
Thank you. I'm going to give you a brief explanation of the process. I'm going to read some information to you and ask you to verify it for the record. Then I'm going to give you a chance to speak and tell us what you did to cause your incarceration and why you think it'd be a good idea to release you. Then the warden's going to give us an update on your behavior at the facility, and we'll allow public comments, 3 in support and 3 in opposition. Then we'll conduct the parole interview. Today we have for parole consideration Tyrone Jackson, DOC number 159715, who's a second felony offender who was convicted of manslaughter. And on June 18th, 1998, was sentenced to serve 40 years in Iberia Parish Jail. Your parole eligibility date is October 21st of 16. Your good time date is not eligible. Your full term date is 10/21/36. Does that information sound correct to you, Mr. Jackson?
Yes, sir.
All right. So what did you do to get yourself incarcerated on this charge?
I take full responsibility for my actions and what I've done and the harm I caused families. I don't want to put blame on my addiction, but I was addicted to some, a lot of drugs, but I had a choice, you know what I'm saying? I shouldn't have been using drugs, first and foremost. On the event of the night, you know what I'm saying, I can remember certain events that happened, but when it did happen, when I came back to my senses, I brought her immediately to the hospital where she later died hours later. But I can't say that, you know what I'm saying, that I didn't do it. I was responsible for it, and I gotta live with that for the rest of my life. And it hurt me every day that I took her life. But I just try and strive, you know what I'm saying, to be a better person now. That's not me. That's not me. I done grown. I done became a better man. I had to apply things to my life that I rejected coming up as a youngster. I grew up in prison, and I just asked for an opportunity to get out and show that I can make everyone have a different outlook on me. I want to make a difference and give back. That's what I strive for.
I think now's the time to release you.
Sir?
Why do you think now's a good time to release you? What have you done in prison to improve yourself?
I've took the majority, every self-help program that was available to me and utilize it in a way to where I had to apply it to my life. You know, I was dealing with a lot of issues in my life coming up. And at first I was in denial, and I had to accept responsibility, you know what I'm saying? Then I had to deal with humility. And it's something I never did, you know what I'm saying, accept. But when I started applying these things to my life, you know what I'm saying, I started seeing things differently, and things started to open up to where I started feeling things and start caring more about other people. You know, I came up to where, you know what I'm saying, I was numb to a lot of things. But now I have a different outlook on life. I just want to have an opportunity to prove myself.
Gotcha. All right. Joe Steph, do y'all have anything to tell us about Mr. Jackson?
Mr. Jackson actually has been at Allen Correctional Center for many years. I kind of watched him mature. I watched him grow. So he doesn't have any significant write-ups at this time. I think he's like 4 years without one. He's taken a lot of programs. And like I said, I've watched him mature in as he's done his time here in Allen.
Thank you. Today, we don't have anybody here in support that wants to speak anything.
There's actually an attorney involved, Mr. Barra.
We got it. I'm sorry. Looking at the wrong sheet. We have Richard Spears, the attorney, who would like to speak. Mr. Spears, go ahead on.
Thank you, Mr. Barra. Ladies, board, I'll be very brief. I can't add much legally. I think that it's very clear what his situation is, and he got a very set sentence, and so we know when the dates are. All I can say is that I have been involved with trying to help him for a long time now, many years. Yesterday, I spoke to him about this, and he actually started crying. And I'm surprised he didn't cry this morning. He was worried about crying, and he cried when he talked about what he did. And so I just want to recount to you that I saw serious remorse yesterday. And I'm surprised he didn't cry this morning. I know he has all kind of different emotions going through him. I'm not going to belabor the law. I know that you all know what it is, and I just would say that from a human point of view, this is a guy that I would let into my home. I would let him be around my family, and I don't say that about many of my clients. So if y'all have any questions about his case, I'm here to answer them, but that's all I would offer.
Thank you, Mr. Spears. We also have Jules Anderson, who's in support of Bishop, and he's on Zoom. Go ahead, Mr. Anderson. I can hear you.
Oh, yes. Good morning. I want to say that I've known Tyrone family for over 40 years. Been connected with his family through ministry when his mother was living, when Tyrone was younger. I understood clearly in terms that what he went through upon the separation of his father, you know, leaving the family and thing as a child. And then he made some, got into a situation in the early stage of his life, and it was very clear that the community and everyone was shocked concerning the situation that revolved around that he was caught up in. But he was able to be responsible for that situation. And then the problem that his mother spoke to me about was that when Tyrone did come home, you know, the short period of time he was home after serving time, that he did lose focus and begin to be involved with some situations that wasn't healthy. And I was concerned about his drug use. And so it was very clear that at that time he had lost focus and got involved in that situation. But I've been kind of communicating with his mother's deceased, not father's deceased also, but from time to time with Tyrone, and encouraging him to, that he had to focus on developing himself and applying himself to becoming a better person, because he had a long time to do. I would definitely never would have thought I would even be speaking at a parole hearing this morning for him. But my understanding is, based upon my communication with him from time to time, that he have applied himself and tried to better himself, and looking forward to an opportunity maybe to work with him in the future, to work with us when we dealing with our young people and other young men in the community, to try to apply a different outlook on life so they won't end up in the same situation that Tyrone ended up in. I think that from the root of it, if he was be given opportunity, I think he'd be a positive influence in our community in making some changes and help us with the programs that we're implementing, working with problem teenagers.
Thank you. We also have Kingor Taylor.
Yes, I'm here.
A friend. You can go to the podium and you tell us what you want to tell us. Who's here at headquarters?
Good morning.
Morning.
My name is Kim Taylor. I'm here on behalf of Tyrone Jackson. I want to say that I have seen him grow into your scene. I've been knowing him about 32 years. I met him through my brother. My brother's a CC dad in the parts of me. The times he kept in touch with us, like with the family, you know, with me. And like when I lost my son, he was there for me. I lost my son to gun violence. So he made my outlook on them different. Because at first I really hated them. I really wanted them to pay, which I still want them to pay for what they did to my son, so they can go to jail and rehabilitate themselves like he did and be a better person when they come out. But I feel Tyrone is a real good person. I've seen him grow. He's way different from what I've been on. He was real numb at first, and now he's real like lovable, like a good person. Like he's a really good person. He's good at heart.
So are you providing housing for him?
Yes.
Today, we have no one present to speak in opposition, but we do have opposition from the district attorney's office and attorney general's office. We also have letters of opposition from the victim's children. The victim had 3 children that spoke out and reached out. We reached out to them and they're all opposed, 2 sons and 1 daughter, strongly opposed to early release. The case has been assigned to Ms. Ledoux, so she's gonna start the questioning and she'll be the one to cast the first vote.
Before I get started, I'd like to ask to go into an executive session. I've got clarification.
Okay, I'll second. Yes. Yes.
Yeah.
Okay, we're in the Wayback Machine a little bit, so I can fast forward, but while I do that, watch the bear. So, Lindsay says, I'm enjoying these bear interludes. To be honest, I am too. And it kind of makes me want to have some nature scenes to cut to from time to time. If you think I should do more of that, put a 1 in the chat. In the meantime, I've fast forwarded past their executive session. Let's see how this all concludes.
You took her to the hospital, which you said, I took her to the hospital, didn't accept responsibility.
Right. The state of mind I was in, I didn't want to go back to prison, and I just, I can't deny that.
And I feel certain that you are doing some good things. Your behavior while you've been incarcerated, your last write-up was a phone.
Yes, ma'am.
Okay, so here's what I'm thinking. Probation, are you parole? You were revoked. You come back with another victim dead, and you've done 27 years, but only until 2021 did you stop and start following rules. Because you've had disciplinary write-ups all of those years until 2021. And I'm sure then you realized, okay, I've denied in 2017, I need to kind of start doing a little better. But you still, after being denied, you have a phone. I need to be confident you're going to follow the rules of supervision.
Yes, ma'am.
How can you assure, how can you convince me you would?
Ms. Ledoux, I can't deny anything you're saying. My write-ups that I did, I'm not perfect. And I try hard every day. It's a struggle to where I'll be on track, then I'll fall off. You know what I'm saying? But I had an awakening. It was 17 after my mom died, you know what I'm saying? It's just, I knew that what I kept doing is wrong. But I had to apply myself. like I said earlier, when I first opened up, I had to apply myself to the things that would change me. I didn't want to really sincerely apply myself. I can say I was doing it, but I really wasn't. It took a lot for me to really come and say, you know, that I was wrong. I accept a responsibility. It took a long time for me to do that, but I had to. And by me doing that, that's a part of my change. That's a part of my growth. You know what I'm saying? I'm saying I don't know the time span that you have to be without a write-up, but I think I'm very proud of myself because if you look at my record, this is the longest I ever been without a write-up. I didn't apply for the parole today. I didn't apply for this. So I heard what you said that I went up in 17, so I'm stopped getting right. No, I didn't apply for this. I got put on the parole board. I don't know how, but I'm thankful for it.
Well, I appreciate that honesty, Mr. Jackson. I'll defer to my colleagues for any questions they may have.
Okay, Ward, I have a couple questions. Yeah, I listened to what you said, and then I see on his forms that he's medium custody and fair conduct. That's usually an alarm to us.
So he's what we consider medium honor. We have certain levels, so because of the amount of time that he has not had a write-up, he was able to earn that status, so he's medium honor. And like I said, he has grown. I have watched him grow. And what he just said, this is the longest he has not had a write-up. And that's what I noticed. When I say that I've watched him grow, I noticed the change. But yes, Tyrone will sit here and tell you, just like I will, that his conduct was rough. And he's been here a while, and so I am familiar with him, but he's matured.
Okay, and then the last one, I just don't know for my own sake, what is a 30B?
Is that last write-up?
That's in 2012. I was just curious. I've never seen a 30B.
I would have to have the actual write-up, Mr. Freeman.
Okay, well, that's okay.
Exactly. I just
It was
know
in
it's
2000.
behavior, but I'm not sure exactly what it says. 30B.
Okay. I have no further questions.
Do you know what the 30Z is? You look like you knew something about it.
Because I can't recall having it in my jacket. I can't recall.
All right. So at the time, what was your relationship with Miss Sparrow?
Well, she's my uncle raised her, and she's like a cousin to me. But I was using her residence as my hideout to get high, to hide from my mom and my girlfriend. And I used to go there, and, you know what I'm saying, and just hide out. Every time I would come from the club or during the day, you know what I'm saying, I'd just go hide out. You know what I'm saying? We were close. And she never did me anything.
What made you do it?
I did some drugs that I couldn't handle. I hallucinated. And for what I can remember about the incident, she kept telling me, she said, you need to stop, you're gonna kill yourself. She just kept saying that. And that's really all I can really remember her saying. Because I started hallucinating, you know what I'm saying? And when I came out of it and I realized what I had done, I immediately brought her to the hospital to try to save us. I didn't want her to die.
What kind of drugs was that made you hallucinate that bad?
I was doing cocaine and acid.
Acid?
Acid tabs.
All right.
LSD.
And when you killed the first person, what made you do it then?
We were fighting. I was under the influence, but I can't blame it on that. I lost my cool. And she came at me with the knife, and it took the wrong turn, you know what I'm saying? Out the heat of passion, and you know, it wasn't no repeated thing. I did something that I regretted, and I took her to the hospital, you know what I'm saying? And it's just, I had to, you know, like I said, I was a lost kid. You know, I didn't understand me myself. I didn't understand. I had to find myself in him.
Thank you. That's all the questions I had. Is that all the questions, everybody? You ready to vote?
Yeah.
All right, Mr. Dew, you vote first.
Mr. Jackson, I hear what you're saying, and I believe you. I believe that you're seeking to do the right thing. There is a penalty that has to be paid. And, you know, today my vote is going to be to deny parole. I'm surprised didn't get hit with habitual, in this case. I hope that you continue down the right path, but because of the nature of the crime, the amount of time served, the opposition, my vote is to deny.
Mr. Freeman?
I also think, you know, you gave a very good interview. You're real honest. I mean, the problem is, this is 2 lives you've taken in your lifetime now. And I just don't think it would be sending the right message to let you out at this time. But keep doing what you're doing and reapply, because you are doing great and you have rounded that corner, as the warden said. So stay positive and then reapply. My vote is to deny.
And I'm going to concur with my 2 colleagues for the same reasons they already said. So what this means today, Mr. Jackson, is that your parole has been denied. And this concludes our business with you.
All right, thank you.
Denied.
Steve Lee?
I'd like to say I was shocked by that, but we're seldom shocked with a denial. So usually I finish the show with just me on the screen, but it seems appropriate today that I finish it with the image from the national park up in Alaska. The salmon are still running, but it appears that the bears have taken a time out, so that's good for the salmon, I suppose. Thank you, everybody, today. After the last hectic 24 hours I've had here at the bunker, this was cathartic. It was a good day. I appreciate it. Thank you to everybody's support. Welcome to Julia, who became a channel member during all of this. Very much appreciated. You'll enjoy it here, trust me. If you haven't already, hit the notification bell so you're alerted when we go live. But we've got coming up on 1,000 videos on the channel, so lots for you to watch, lots for you to do, lots of good benefits. So be sure to check out your member benefits, and I think the pre-show, in my opinion, is the best. Because you just get to hear me do whatever I want for about 25 minutes, so it's great. We'll be back tomorrow, 10 a.m. Eastern, 7 a.m. Pacific, again, a half an hour early for channel members. Appreciate all of you a ton. Go have yourselves a great Wednesday. We'll see you tomorrow. Take care. God bless.